My lord. My lord, I have filed one IA in the disposed of matter for extension of time.
Come on.
My lord, bench needs composition of your lordship and Justice Rama.
Just tell him tomorrow, sir.
Tomorrow. Fresh admission item number 1.
May I please, lordship?
The khata number 630 and plot number 870 and khata number 621 and plot number 860 belongs to government landlord. The opposite party number 628 unauthorized encroach the same by making permanent structure over the landlord. Though the land has not been settled in their favor, but he has unauthorized occupied the same. Annexure for my representation has not been considered by the Tahsildar.
Representation shall be examined by the Tahsildar Tangi, and after notice to the petitioner as well as opposite parties 6 and 7, and giving them a hearing. A reasoned order shall be passed not later than 15th May and communicated to the parties within a week thereafter. Court clarifies it is not expressed to the
Supplementary list item number 2. Item number 2.
pass.
Item number 3.
Memo taken on record. Dismisses not pressed.
Item number 4.
May I please, Madam? Madam, no, the Provident Fund is a deposit scheme. The member of the scheme can take loan from that on net security and has a return. But this case, the member took away, he was released the entire Provident Fund without payment of the loan of 17,000 way back. Now, on audit, it was found that he has not returned it. Now, he has that, his wife is receiving family pension. So, after audit, it was the matter placed before a committee constituted for that purpose. They have said.
Item number 4.
4.
Writ Appeal 70 of 2009.
Again, not yours. Government or no. Provident Fund. So now, we said you should please return the money with interest. Now the Honorable Singular say, relying on Rafik Masi, has said you will not return. That is the case, my lord. Rafik Masi is applicable to service matters, not to Provident Fund or loans, my lord. I have given the judgment of Rafik Masi, and my lord can see that. That is the point. It is a funded scheme, loan taken, out of that fund, we pay the pensions, etc. Unless money is come back to the fund, how will you manage the scheme, Lord? That is the case, Lord. Rafik Masi is not applicable to this type of cases, Lord. My assumption.
Notice returnable. Notice on that stay also.
Man.
But you bring it up for hearing 3 years later, sir.
Man, because of the corona, it could not be listed.
This is not an excuse, sir. Actually, all 3 years are over.
Sorry, sir.
Not for sorry. Why should we go after these are what this is? Employee is dead, is it?
My lord.
This is only after the widow.
My lord.
We'll leave the question of law open, sir.
And he has to return the money of the fund, my lord, not only.
Yeah,
he is getting pension. He is getting family pension, etc. Everything.
The writ appeal is being listed 3 years after the judgment of the single.
No, filing time, not time, but time filing time.
And the respondent is the widow. What must be her age? She must be quite old.
We had started deduction in time, my lord. After the.
What is the age, sir? What is the age of this?
Age, my lord.
Age of the lady.
Age is not given here.
It's undoubtedly the recovery at this stage of the outstanding loan from the widow would cause her enormous hardship.
Rafik Masi is not applicable in any case, madam.
Correct.
Madam.
The question of law arising from the impugned order is left open for consideration in some other appropriate case. It is clarified that the impugned order will not constitute the precedent.
All right.
The appeal is disposed of.
Item number 5.
My friend has appeared.
So respondent has appeared. Let him serve a copy of the writ appeal to me. We have not slab breakup.
What is the matter about, sir?
My lord. The opposite respondent before my lord, John daily wager in one corporation, similar for example, corporation 85, were dismissed for negligence in duty. 87, he went out of job. In 90, there are regulation in that corporation. He was not there. He was not considered. Now he challenged the termination in this honorable court, and in 1992, my lord directed, well, kind of find that order at page, quoted as page 6 of the merit appeal. May I place, my lord? Page 6.
No, but he'd already come and he'd already got an order in his favor.
Well, I'm showing you how it is. Now, the first round, my honorable Justice Hansari of Division was, he has passed this order. As Parasi have quoted. Next question is what consequential order should be passed in present case relating to reinstatement as well as the payment of arrear salary. Add to this, Sri Das, he has been instructed that the petition is presently occupying the post of General Manager, North Economic and Financial Company Limited, Udala branch. Accordingly, Sri Ratha, however, has no instruction from the petitioner who had met him in the last week. In view of this, we have to order for reinstatement. Of course, it would be open to the petitioner to report back for duty in so far said necessary to him in as much as he was earlier office assistant. In the meantime, has
So
become
again,
a general manager.
this order is 3 years old.
My lord, this order 92, my lord, not it was 92. This order passed in 92.
Impugn judgment, sir.
Well,
Impugn judgment is 3 years old.
Just 1 minute. Now, my lord have never said about regulation. Only reinstated as a deliverer, reinstated in deliverer in 92. Then he filed again for that as regularized with effort from a junior service. He has not the service below regularized. My lord knows, unless there is a post, he is there, he cannot regularize. Now, in the second round, this honorable court has passed the order at page, my lord, 39. 30, rather 40, my lord. 40, last para. So far as the claim of petitioners regarding counting an apportioned period towards valid service in the concern, we direct that the OPs to count the period of service during which petitioner was out of service, but due to dismissal towards valid service. So far as the regulation is concerned, we leave it to the authorities to consider the same after counting the period during which retirement was out of job toward valid service. It goes without saying that if the junior the petitioner has been regular, he can do it. But now, while this one never said regular from the last date, previous corporation. Now, after this order, we considered his case and the managing director passed the order at page 45, referring to Uma Devi, there is no post available, he cannot regularize. That is the order. Now, only singly has said, no, you have to regularize from the day when you was junior regularized. You are not in service. Recent decision of Supreme Court, Uma Devi as well as this Supreme Court, Vibhuti Pandey, Vibhuti Shankar Pandey case, recently of the country. It says, only there is a post available, you can regularize. If you after he regularized from the after the order of the second case, not from the date of 90, he will regularize. You are not in service, others regularize, how can he become like this? That is my case.
Now, can I ask a question, sir?
My lord, sir.
With your kind permission.
Yes.
So you're for the other side.
He is the other side.
I'm asking him a question, sir.
My lord.
How old is this impugned order?
Impugned order is, my lord, it was passed on 20th February 2020.
How many years ago?
Almost 3 years.
Almost or more than 3? More than 3.
I cannot dispute.
My arithmetic is very bad, sir. We both sit together and start calculating, then disaster.
Can I answer?
Your arithmetic becomes worse than my arithmetic then.
Mine is yours.
Now we are in competition. Whose is worse?
No,
in my 4th class, they told me this is more than 3 years. Yeah, it's correct. All right. At least we agree on that.
Right. How can I disagree?
Good. So what have you done in these 3 years?
My lord,
What have you done in these 3 years?
my lord, not listed, my lord, what can I say?
So nothing.
Only
to do.
because my lord came.
So you have to do nothing.
My lord,
Not listed means you have to do nothing.
yeah, we are
Yes.
but not listed, my lord.
High Court not listed, you have to do nothing.
We are waiting for the list.
Wait. So you don't have to obey the order. Keep waiting.
He has retired in the meantime.
So he has got relief. You don't have to do anything.
No,
You have
we are-
lost the case. You do not have to do anything. That's your attitude.
No, not.
What else? You lost the case in the single judge.
Well,
You have an order against you. Do you have to do something or nothing? Relax.
I have filed a mistress also.
That's all. After filing, relax. That's the attitude.
I am grateful my lord listed this order.
Oh, very grateful, sir. Very grateful. We are also extremely grateful to you for appearing. What have you done in the last 3 years?
No, my lord.
What is the attitude? You are Orissa State Financial Corporation.
My
correct?
lord.
So how do you treat orders of the High Court?
That is my mistake, my lord.
Huh?
That is my mistake.
So how are you going to make good that mistake?
Leave it to my lord.
You first comply with the order.
My
It will
lord,
be subject to the outcome of the appeal. You comply with the order.
compliance, he will go here, already retired, he will go across the money.
So you decide what you want to do.
So let him have give security for that.
First you show us your compliance, then we'll talk about all that.
I will
What is the amount due to him? Have you calculated?
You'll get it from back wages, regular scale from 90.
You want us to both to sit down and calculate, or
I will calculate.
you will calculate? Very good. When will you calculate?
Next week,
Next week you'll calculate. You'll also deposit in court.
I will calculate and take instruction.
Sorry?
I will calculate and take instruction. I instruct them to comply.
The impugned order is more than 3 years old. Since the appeal was never even mentioned for listing by the appellant, there was no occasion to stay the impugned order. Yet, counsel for the appellant, learned senior counsel for the appellant informs the court that the impugned order has not been implemented. What about now? I'll ask you the question, sir.
Yes, my lord.
Your client succeeded 3 years ago.
Yes, my lord.
What did you do?
My lord, I have asked them to give me pension. They have not yet given pension.
Pension-
So you do not know what you should do.
My lord,
So as a lawyer, you do not know what you should do.
I should have filed a contempt petition.
So we are giving free legal advice here. Orissa is the best place to be, sir. People who succeed in writ petitions don't do anything. People who lost the writ petition don't do anything. First class. You cannot have a better situation. So people who lose their cases are very happy. People who win their cases are wondering, we thought we won the case, but our lawyer is not giving us any real relief. And not just you.
Yes,
Across the board. Poor workmen, poor widows, everyone who was supposed to have succeeded in this High Court, they're still waiting. What their lawyers will do next. Not implemented, despite there being no stay. Senior counsel of the appellant informs the court that the impugned order has not been implemented. Paragraph. Considering that the respondent is already superannuated, as noted in the impugned order, the court would like the appellant to deposit in this court the entire amount due to be paid by the appellant to the respondent, together with the calculations. Not later than
2 weeks, maybe at least 2 weeks. Maybe.
it will be more than that, sir. It would happen within 2 weeks. 24th April,
Manner.
2023.
Manner. 24th April. Actually, my lord, until my lord has joined,
List on
he was
first.
not. We are grateful to my lord, because old matters are coming up.
We'll all get older and older.
My lord.
Clients will not get any relief. All right.
Item number 6. Supplementary list item 6.
None appears dismissed.
Item number 7.
Item 7, that's a contractual matter, your worship.
Item number 7, but this is a single matter has come in on a lordship's board. that 5 out of 6 matters are already connected to the specialist matter, item number 1.
So it is
So
taken up along with
it's
the
better to
specialist.
take up this matter along with those specialist matters. So that
Okay, same. All right.
Item number 8.
Item 8, my lord, it relates to UGC scale of pay, where the honorable single judge has allowed the matter, deciding, relying upon Alok Mishra. This, my lord.
And that Alok Mishra has been stayed.
My lord.
Ah.
So, my lord,
Similar orders.
WA 486 of 20.
Where is the order?
I am passing. Yes, ma'am.
Same order. When is this matter coming up, sir? 24th August. All right. Same order, 24th August.
Item number 9. Item 9.
My lord, I have given that same order. Sarat Parida.
8th May.
Item number 10.
Item number 10, my lords, this matter may be tagged with this today's supplementary
All
specialist.
right. All right.
Grateful, man.
Item 11.
Rehabilitation assistance.
30th August.
30th August.
On.
Item number 12.
May it please, my lord. The appellants were all recruited as forester, my lord. My lord, after the selection and appointment have been made as foresters, the appellants are put in the Kendulif division, my lord. As there was a necessity for their work, the state government relaxed the provision of going for training and asked them to join in the post. Accordingly, my lord, they have joined the post. Now, after they joined, my lord, from the year 2013 to 2017, 4 gradation lists were published in which the present appellants were sold above the respondent, my lord. Thereafter, my lord, in the year 2019, suddenly the gradation list was altered and the present appellant was sold below the respondent on the plea that you have not taken training, you have joined training later on, and others, those who have joined as forester in other divisions, the territorial or etc. So they will be shown senior. Without taking into consideration, my lords, the relaxation provision that has been extended by the state government for these people, this was challenged. And while the matter was, one of the appellant was there, my lords, we filed our intervention application to be implemented as party. Matter was listed from time to time. No orders were passed so far as the intervention petition is concerned. And ultimately, the order was passed affecting our right. That's why, my lords, we have filed the appeal.
No, but writ petition is dismissed.
Yeah, exactly, my lord. Writ petition, because that's why you are in the appeal, my lord.
No, but you were the intervener. You're not the petitioner.
No, you are the intervener, my lord.
What happened to the writ petitioners who lost? They have not filed an appeal.
He filed an appeal, but during his pendency, he got the promotion. So he did not press the appeal.
Where's that order?
My lord, that Prasanna Kumar Hanuman, he did not press it because he got, I'll give the number, my lord. Get that?
11 2023.
No, reach appeal.
11 of 2023.
11?
Of 2023.
Reach appeal 11 of 2023, my lord.
When was it listed, sir?
That was listed and that was withdrawn. Get withdrawn. As he got the promotion. It doesn't.
Ah, I got it. All right. The present appellants were the interveners in writ petition civil bracket OA number 887 of 2019, which has been dismissed by the learned single judge by the impugned judgment dated 22nd December 2022. Paragraph. Mr. Rathwell, learned senior counsel appearing for the appellants, informs the court that the original writ petitioner, Prashant alias Prashant Kumar Hanuman, had also filed writ appeal number 11 of 2023 in this court, challenging the impugned judgment. But since he got his promotion in the meanwhile, he withdrew the said writ appeal, which was then dismissed as withdrawn by this court on 2nd February 2023. So Mr. Rathwell submits that the present appellants had sought intervention to be heard along with the writ petitioners, since their rights would be adversely affected if the gradation list which was challenged was to be confirmed. Paragraph. Notice returnable. August 17th. You see, notice is accepted by on behalf of opposite party respondents 1 to 4. Notice will now issue to respondents 5 to 11 by registered speed post, and the tracking report shall be placed in record by the next day. All right. Mr. Kuntia, 1 to 4. All right.
Item number 13.
My lords, there is an interim application.
Notice on that also.
My lord.
There will be notice on that. Right.
Item number 13.
Please, my lord. My lord, here, as per the announcement made by the Honorable Chief Minister to set up that Adarsha Vidyalaya, my lord, that Otavira is one of the place where has been selected and so declared to set up the Adarsha Vidyalaya. That is item number 36 by Annexure 1, Adarsha Vidyalaya. And accordingly, the construction was also proceeded, and the student also took admission in that institution. Thereafter, my lord, thereafter, that they have changed their school to some other place under the pressure of that local MLA and others. Only, my lord, that let the collector be directed to take a decision.
He's already taken, sir.
Take decision only, my lord. What they are, he cannot change the place once it has been announced by the chief minister as well as the government. So, and also work was on progress.
There's high tension railway line and all going there.
That because
electric line.
Though the line was there, the school is also another school, and our offices are also still functioning. This is a flimsy ground only because
there's a detailed reason. Come to page 38,
sir. That is, my lord. My lord, though these situation is available, or another schools are also functioning. What is the wrong to?
Why risk it, sir? When there's high tension electric line.
High tension because this place that has been selected by the Tahsildar, by the BDO, Polishova, they are also hold a meeting.
Come to that last paragraph.
Sir.
From the report submitted.
My lord. Warehouse, one private warehouse before and the one government warehouse after a distance of average 1 kilometer from the proposed.
Where are you reading, sir?
Page 39, sir.
38, come to 38.
38, sir. Yes.
Last paragraph. Yes. From the report submitted.
Yes. As per the instruction of the collector.
No. From the report submitted.
Last. Yes. Okay. Yes. The committee inspected the.
You have. I don't know whether you have the correct paper book. This is what you have filed in the court.
Yes, it's the same. Sir,
What does the last paragraph read?
sir.
I am just referring.
No,
this.
let him read, sir, because
No, because he has not sought copy, that is why I am just. From the report submitted by the committee, it is seen that out of both the sites, the selected site at Bhoipur is at a more beneficial location than that of Lahonda. Students will definitely face problems in crossing the railway line and heavy movement of traffic in presence of warehouse on the way to Lahonda. Hence, it is concluded that Bhoipur is the better location. It is a reasoned order.
Well, before that, before declaration by the Honorable Chief Minister, he has also got
all.
my lord, the feasibility report also received by the collector, Tahsildar, BDO, as well as the police. They have stated, yes, this is the right place to be set up. Thereafter, when my lord, because under the pressure of the local MLA, he has changed the site.
Right.
Nowhere in the state of Orissa, though there are different places has been selected, nowhere there was any change. But this is the place where it has been changed.
the location of a school is the subject matter of the present writ petition filed as a public interest litigation. To stop, this is the second round of litigation. Earlier, the writ petitioners had filed writ petition civil 16154 of 2022, which was disposed of by this court on 11th August 2022, requiring the petitioner's representation to be examined by the collector Badgar. Stop. That exercise has since been completed, and the collector has passed an order on 12th October 2022. After perusing a report submitted by the committee set up to make a site visit, and site visit. Stop. The committee examined both locations at Bhoipura and Lahonda and concluded that the site at Bhoipura was better suited for the purposes of a school. Stop. The reasons given in the tabular column were perused by the collector, who concluded as under. Take from the last paragraph, page 38. Paragraph, Mr. Panda, learned counsel for the petitioner, submits that since the Chief Minister had earlier announced that the school would be opened at Lahonda, that decision ought not to be altered, and that the shifting of the site was due to political pressure. Full stop. This court is unable to agree with the above submission. Full stop. Detailed reasons have been set out in the order of the collector, explaining why the site at Bhoipura was better suited for a school. The court is unable to find any reason to interfere with the impugned order of the collector. The petition is accordingly dismissed.
Item number 14.
None appears dismissed.
Item 15.
Yes, Mr. Das. You have to unmute.
Under item 14 permitted to withdraw my.
14 dismissed is withdrawn. 15. Yes, Mr. Das.
15.
Against the unauthorized construction, my lord, the petitioner has filed his representation by annexure 4, which is pending before OP number 1, my lord.
All right. The petitioner has representation.
But the
Date in 10.
encroachers are not parties to
Oh,
this.
they're not parties, is it? So you have to make them parties, sir.
I may be permitted to withdraw with a liberty to file.
All
before
right. Parts of the petitioner seeks leave to withdraw the present petition, liberty to file a fresh representation, naming the encroachers, and after following up its representation to seek appropriate medicine. This post was withdrawn with liberty is paid for.
Item number 16.
Item 16 infructuous.
Infractuous dismissed.
Item number 17.
A week's time to remove the defect.
What's the matter about, sir?
The matter is a PIL. Actually, I am not prepared also today. There is only, it has come for the removal of defect. We pray only a week's time. Next,
all right. Tell
next
us-
week, any date, my lord.
No. Tell us what the matter is.
My lord.
Implementation of Spurti scheme, choir sector, corrupt officers. This you can go to the local acts. For the
Madam?
subject matter of the petition, as is evident from the relief prayed for, it is evident that the petitioners have an adequate, efficacious remedy before the Lokayukta, permitting the petitioners to avail the said remedy. Petition is disposed of.
Item number 18.
Please, my lord. My lord, my prayer is for direction to release the crop insurance benefit because there is a crop insurance policy, whereas any damage, any calamities faced by the farmer, that they have to liable to receive the that compensation, that insurance benefit. But till today, they have not released the insurance benefit.
No, but come to the order, sir, passed.
Sir.
This is again second round.
Yes.
Come to page 43.
My lord. My lord. Whereas the Honorable High Court of Orissa dated 17/9/21 in double PC number so-and-so, CMFL so-and-so, the agricultural farmers of the Kuchinda subdivision through Sushant Kumar Pada, the present petitioner, and other state of Odisha and others had ordered the petitioners will make a proper representation raising all the grievances or the present petition to the collector come the district magistrate Sambalpur opposite Pandavachili, not later than 1st November 2021. If such representation is made, opposite party number 3 will examine it, and after issuing notice to the petitioner and giving the hearing to one of them as may be nominated by them as past region order, there are not later than 3rd January 22. A copy of the said is so. And whereas the petitioner filed the representation to the opposite point of 3, collector district magistrate Sambalpur on 30th 9, 2021. And whereas the petitioners are informed, notice and so to nominate one person who will represent the case before the OP number 3.
Where is the copy of your representation? 30th September.
The representation is there. Can be taken up for next week.
All right, at the request of Mr. Panda. Please, 19th April, defects be cured in the meanwhile.
Item 19.
19, my lord, encroachment, annexure 2 is pending before OP4.
You made the encroachers a party.
Private opposite party.
Copy is not there.
Copy, sir.
Encroachers particular.
Only one encroacher.
My lord. Okay.
There is proof of delivery of this representation.
Proof, my lord, page 19, my lord, they have received. Page 19. Those they are received.
All right, this petitioner's representation shall be examined by the Tahsildar. Suliapada, District Mayurvansh, and after notice to the petitioners and opposite party number 5 and giving them a hearing, the reasoned order shall be passed not later than 15th May 2023 and be communicated to the parties within a week thereafter. Court clarifies it is not expressed in
Item number 20.
Water channel culvert adjacent to the national highway is encroached by the OP number 4. So, my lord, by the order of the Honorable Court earlier on our petition, the Tahsildar passed the eviction notice. Thereafter, the OP number 4 lost his case both before the sub-collector as well as in the Tahsildar. So, presently, he has filed a revision before the collector, 1/22. So, we have also, my lord, filing objection before the collector. But in the name of a pendence of the revision, no action is being taken by the Tahsildar, saying that the revision is pending before the collector.
All right.
So,
it is stated that
rainy season
OPLE revision case number 1 of
The collector may be directed to
filed by
dispose of
opposite
Yes,
party
yes.
number 4 is pending before the collector. Balashur,
Collector,
Since-
2, my lord.
it's been pending since
Since, my lord, 28/1/22.
28/1/2022. paragraph. If the above revision case is still pending, then the collector will ensure that it is disposed of by a reasoned order not later than 1st June 2023. A copy of this order be sent to the collector, Baleshwar Court.
Obliged. Item number 21.
Item 21, may I please your lordship?
Yes, please.
Your lordship, the present petitioners are the villagers of the Khairamal Gram. Here the petitioners have challenged the inaction of opposite party number 4 for not taking steps for eviction of opposite party number 6, who has encroached into the plot number 43, khata number 187 in the district of Subarnapur.
All right. The petitioner's representation, bracket annexure 2 series, will be examined by the Tahsildar Vinka. And after notice, the petitioners and opposite party number 6. And after giving them a hearing, a reasoned order should be passed not later than 1st June and communicated to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Item 22.
Obliged.
22 here, my lord, pursuant to public notice, the chairman, Panchayat Samiti and also Sarpanch, they have passed resolutions and that is pending before the government. Lordships have ordered similar order. By 31st or extended period, lordships have done. Annexure 2 series, my lord, is the objections.
All right, same. Okay.
Item 24 also same, but annexure 3 series there.
All right. So annexure 3 series in item 24. All right.
Item 23.
23, 24 same, no? Oh,
22 and 24.
22 and 24.
22, 24.
Item number 23.
Right, please, your lordship.
Yes.
The song Bande Utkal Janani has been declared as our state anthem from the 7th June 2020. But the government has been promising to release the official version of the song, but it has not released so far. What it has led to is that people are presenting the song in very fanciful and different manners. And the national anthem, lords, the official version was released long back and it is only played accordingly in the official functions everywhere. But the state anthem, they have still not released the official version. Lordship may see Annexure 1 and Annexure 2. They have been promising that the official version will be released. They have said that Guru Balakrishna Das's composition, the tune is accepted as the official version. But until the tune is not released, Lordship knows they sing in different manners. The Lordship has excellent sense and knowledge in classical music, lords, and other forms of music, Hindustani and Carnatic.
Everything doesn't have to become a PIL.
Millers?
Every issue should not become a PIL.
No, Millers. I am only praying that the official version may be released as promised by the government, because they have said that the Balakrishna Das's tune, Sangeet Sudhakar, as in 1950, it was composed, is the official version.
Can be resolved. Just ask them to look into this.
My lordship may see Annexure 1 and Annexure 2, Millers.
He sent an email, representation by email.
That representation can be considered by the Additional Chief Secretary.
All right.
Opposite part number 2.
The petitioner's representation, bracket Annexure 8, be examined by the Additional Chief Secretary,
and whether
Language, Literature and Culture Department, Government of Orissa. And an intimation be sent to the petitioner not later than 1st May 2023 about the decision on his representation.
And Lord, may I request one thing? Lordship may say that representation sent by the petitioner by email on dated 26th January 2020.
Yeah, on 26th January, bracket Annexure 8 is.
2015.
Yes, 15 I have sent a representation.
Oh, that is then he has to file a fresh representation.
Subsequent to that, there was an online petition in change that all which more than 100 people have signed.
Fresh representation. That is better for him.
Lordship may see the annexure that subsequently another online petition has been filed, my lords. Subsequently, Lordship may see Annexure 9. This is an online petition in change.org. More than 100 persons have signed, and the Department of Culture was a party in that. They have been receiving notifications about this.
A copy of the said representation will be provided to the Additional Chief Secretary by the Council for the Additional Government Advocate. Yes.
My lord, petitioner himself, he is the petitioner. He will give the representation and get
Can give it, sir. Why don't you send it?
Okay.
All right. The petition is disclosed. Right.
Item number 25.
It's regarding this eviction of slum dwellers, my lord. They have been living in a particular place over last 50 years. Now, Your Lordship, last time wanted to know the present status. To my instruction, they have been still continuing. Government has provided lot of facilities like Anganwadi center, big water tank, all these things, electricity connections, and all these things, my lord. And they have been earlier.
Lasted about 2 adjournments taken, Mr. Monty.
Yes, my lord.
Nothing happens. People keep taking adjournments endlessly. 3 adjournments. 10th October was first adjournment. 21st November was second adjournment. 27th February, third adjournment.
Lord, what is saying that they are still in occupation, must be. Then I have to get the status report.
That's the same thing, sir. Despite 3 adjournments sought by the Council for the State on 10th October 2022, 21st November 2022, and 27th February 2023 for instructions. Even today, more further adjournment is being sought.
My lord, opposite part number 3 is to furnish instruction, I think, OUAT. They have not been noticed. Orissa University of Agriculture and Technology.
No, I don't know whether they have.
It is within their campus.
No, they are near the campus. It's a slum near the campus. Near the OUAT hostel. Government land. This is government land, sir.
And government land.
They say that
there are 58 paragraphs. There are 58 appellants resisting eviction from government land. Resisting eviction from a slum on government land, which happens to be located near the OUAT.
OUAT.
Yeah, OUAT men's hostel. Paragraph. Where is the impugned order?
Impugned order, Annexure 1, page 17.
OUAT was the opposite part number 1 in the
1 and 2
writ petition. 1 and 2. So they must be noticed, my lord, because this is
we'll
all.
Do that. We'll do that. You say notice is accepted on behalf of opposite parties 3 and 4 by Mr. Monty. Notice will now issue to respondents 1 and 2 for registered speed post returnable on them. Tracking report in case. The state will file an affidavit informing the court what the current status of the appellants is and whether there is any scheme for rehabilitation of the appellants who claim to be staying in the location in question since
last 50 years.
Since the last 50 years, 50 years. Stop. Status quo be maintained till then. List on till the next date. List on 11 September.
Item number 26.
None appears dismissed.
Item number 27.
None appears dismissed.
Item number 28.
Same order.
Item number 29.
Same order.
My 29 UGC scale of Alok Mishra case. 24th August. August na April. August.
I was told that the next date before the Honorable Supreme Court is 24th of April.
This other matters have been fixed. 24th August.
Same order.
Item number 30.
None appears dismissed.
Item number 31.
My lord, I am 30, my lord. 30 I am there.
30 less.
My lord, My lord, 2 weeks time to rectify the mistake.
No, it's 2020 matters. What is it about?
My lord, this is regarding enforcement of the bank guarantee of the Pollution Control Board, which was rejected on the sole ground that there is no jurisdiction of this court.
Yeah.
The pollution control measure, my lord, by the central government, the bank guarantee has been taken.
So you have other remedies, sir.
My lord?
You have other remedies.
My lord, there is a decision that for the public law element.
Yes. This is all you have to file a suit, sir. You have to file a suit.
Your lordship, if you lordship permit,
the impugned order
I will give the decision.
Permits permits the appellant to approach the appropriate forum for relief regarding forfeiture of a bank guarantee. Full stop. The dismissal of the court finds no error committed by the learned single judge. The writ appeal is accordingly dismissed.
Item number 31.
May I please? Lordship, turn to Annexure 5 in the impugned order. That your Lordship remember that case your Lordship has already decided the issue that the collector has jurisdiction for transfer. That in respect of GRS. My lord, I am giving that copy. My lord.
Notice returnable. When is there any similar matter?
Yes, your lord. No, your lord
has already disposed of.
Yes, my already decided.
Notice returnable. 11 September, there shall be a stay of the impugned order.
Item 32.
None appears dismissed.
Item number 33.
33 writ appeal is not maintainable.
All right. Disposed of is not maintainable.
Item number 34.
Sir, I may be granted 1 week time, my lord, because the file has been traced not out, my lord. Sorry, my lord.
No, we won't. This is a 2020 writ appeal, sir.
There are 2 defects also. I have to comply.
I know. Not for 3 years. You cannot wait, sir. Sorry about that.
Sir, I have not traced out my file, my lord. At least one time.
Then you revive it after you trace it out, sir.
Yes,
sir. Counsel for the appellant states the file is not traceable. It is end. Defects have not been cured for over 3 years now. Dismissed for non-prosecution with liberty to the appellant to revive it as and when the file is able to be traced.
Item number 35.
35, my lord, and finally, it's also cost the proceeding, my lord.
35, writ appeal 776.
35, my lord.
35, my case. The writ appeal.
You have to wait, sir. That's in the separate list.
LMC. This is not that.
That's a separate list.
That's a separate list.
35, my lord, sir. The product is 8th May.
8th May.
Item 36.
36, my lord, may kindly see page 50, the impugned order of the Honorable Single Judge. My lord, for the master-servant relationship ceased on account of superannuation of the petitioner, there is no point in continuance of the disciplinary proceeding.
It is limitation, it is limitation.
My lord,
what's the date of the impugned order?
Impugned order date is 29/1/2020.
All COVID periods, sir.
It is directly contrary to the limitation. Rule 7.2, man.
So this is clearly erroneous, sir.
Yes.
There can be disciplinary proceedings even after retirement. Disciplinary proceedings can be there even after retirement, sir.
After retirement.
Yes, why not? There are enough rules for that.
No, my lord, rule is specifically, my lord, for withheld or to debar the person to get the pension. That is the intention of the statute, my lord. Here you will also kindly see what is the imputation against the petitioner. What are the charges against the petitioner? There is no pecuniary loss at all. The charges.
The ground, you can't say that because he's retired, it should be treated as closed. That
no, my lord, you will also kindly see the rule first. Rule 7, my lord.
Yes.
What is rule 7?
Yes.
Let me place that, my lord.
Rule 7.2.
Let me place, my lord. The government, one is important, my lord, not two. The government reserves to themselves the right of withholding a pension or gratuity, or both either in full or in part,
or withdrawing a pension in full or in part, whether permanently or for a specified period, and of ordering recovery from a pension or gratuity of the whole or part of any pecuniary loss, my lord, caused to the government, if any departmental produced proceeding, my lord. Pecuniary loss, my lord. That is specifically.
So you went to the court at a stage when the disciplinary inquiry was still pending, or is it over?
It is pending, my lord,
So
for a
at
long
that
time.
stage, it was premature.
Now, what is the departmental proceeding your lordship should take into account, my lord? Whether that proceeding, what is the departmental proceeding your lordship kindly say? Well, if charges is there, no pecuniary loss to the government, and whether that departmental proceeding shall continue, my lord.
The ground on which the single judge has dismissed the writ petition.
No, allowed the writ petition.
That's right. Yes. On which he has allowed the writ petition is that merely because you've superannuated, there can be no disciplinary proceeding. He has not discussed what you're now discussing, that there is no pecuniary loss and therefore this rule is not attracted. All that is not even discussed.
My lord, then
merely because you superannuated, the law, the single judge has said, okay, you're superannuated.
Everything
no
was
disciplinary
placed, my
proceeding.
lord, that was order was passed during
That's the whole
period.
problem. You see, the impugned order, notice the accepts notice with the consent of parties, the writ appeal is heard finally. It is seen that the respondent had filed writ petition civil 16417 of 2019, challenging the disciplinary proceedings.
Continuance of disciplinary proceeding after superannuation.
1 minute. Challenging the continuation of disciplinary proceedings initiated by a memorandum dated 24th September 2014 on the ground that it could not have continued after his superannuation. Paragraph 1. At the very first date of the hearing of the writ petition, the learned single judge appears to have accepted this proposition without examining Rule 7, is it? Oh.
Rule 7 2A.
No, enter Rule 7, my lord.
Not without examining Rule 7, bracket
1 and 2
of the pension rules, right?
Yes, Odisha Civil Service pension rules.
Of the Orissa Civil Service pension rules, which deals with situations of continuation of disciplinary inquiry after superannuation. Paragraph. Although Mr. Monti, learned counsel for the respondent, public writ petitioner, sought to contend that the inquiry could have continued only if there is any allegation of pecuniary loss caused to the government by the respondent, and that there is no such allegation in the present case. The court finds that since the writ petition was disposed of on the very first date, without any opportunity to the present appellant to even file a counter affidavit, there was no occasion for the learned single judge to even examine such a contention. Stop. On that short ground, therefore, the impugned order is set aside, and writ petition civil 16417 of 2019 is directed to be listed before the roster bench to the single judge on 5th July 2023. The present appellant will file its parabase reply to the writ petition not later than 27th June 2023. And the respondent, that is the writ petitioner, will file a rejoinder, if any, thereto on or before 5th July 2023. No further time will be granted to either party for the above purpose. The learned single judge in the roster bench is requested to proceed with the hearing of the writ petition on merits and dispose it of as expeditiously as possible. The court clarifies it has not expressed any view on any of the contentions of the parties. The writ appeal is disposed of.
Obliged.
Item number 37.
None appears dismissed.
38.
None appears dismissed.
Item number 39.
39, may I pray, Lordship, may take up this matter tomorrow because I was appearing for some of the parties.
My lord, may I pray, my lord, on next Tuesday, my lord?
All right, next Tuesday. At the request of counsel of the appellant, next Tuesday.
Mr. Khuntia may not handle this.
I am submitting that.
All right.
Item number 40.
Item 40, I mean VC, my lord. Here is
Yes.
the case with regard to rehabilitation assistance. Page 8 is the impugned order. The order passed basing on a judgment passed by this honorable court, which was subsequently set aside, my lord. Here the point, because I had applied under the old scheme of 1990, and
Now the matter has gone to a larger bench, sir.
But that is pending, but no stay has been come because there has been mixed opinions, my lord.
Correct. So we're taking up all these matters on 8th May. No, 30th August. 30th August. You simply say list on 30th August.
Oh, bless me.
Item 41.
41, my lord, Sartopal. 8th May.
8th May. All right.
Item 42.
42, my lord, that's special list contractual matter. Contractual matter, it can be taken up with that special list.
Special list. All right.
Item number 43.
None appears dismissed. That IA is allowed. The writ appeal is disposed of as withdrawn. With liberty is prayed for. The next date of 18/9/2023 is cancelled. All right.
Item number 44.
The rehabilitation 30th August.
30th August.
Item 45.
May I please, your lordship? Page 77 is the order. Without providing opportunity, my lord, the case disposed of. Your lordship has been pleased to deal with similar matters. My lord, on 20th, that is writ appeal 18, 19 and 57. Prior to that also 3 writ appeals. May I just with your lordship's kind permission produce it? On the first day itself without any counter. And
but who's appearing? Nobody's appearing, the respondent.
This is for the first time.
All right. Notice returnable 1st May. Notice additionally be served on counsel appearing for the respondent. There shall be a stay of the impugned order.
Grateful mind.
Item 46.
46, 47, Sarath Parida, my lord.
All right. 8th May.
Item 48.
48, my lord, this promotion, the disciplinary proceeding, my lord. I've given the order.
When is it listed, sir?
27th.
27th March.
My lord.
Which is Monday. All right.
Item 49.
So 49, my lord, was special list, man.
All right.
Item number 50.
50 also, my lord, special list.
All right.
Item
51 same.
51.
51, my lord, single day disposal.
Single day disposal.
51, you say, pass a similar order. That early month. Just say on the short ground that the impugned order was passed on the very first day without any notice to any opportunity to the appellant to file a reply to the writ petition. It is hereby set aside. And the writ petition is directly listed before the Lord Single Judge. On 10th July, the present appellant filed its para-based reply the 1st July, and the respondent writ petitioner will file a rejoinder, if any, thereto by 10th July. No further time will be granted to either party for that purpose. The Learned Single Judge is requested to proceed with the hearing of the writ petition on merits and dispose it off as expeditious as possible.
Item number 52.
52, rehabilitation assistant matter, 38. 30th August.
Same.
Item 53.
53 is regulation 25-4, man.
25.
This is a different matter, your lordship, not similar. In that case, your lordship, in both cases, your lordship is granting stay. That is, the employee has given the undertaking that he will not claim regularization. But this is not that case. Here, your lordship, no such undertaking has been given by the respondent number 1. And your lordship will see by citing this judgment, other employees, your lordship, their services has been regularized and they got the relief. That is your lordship I am just giving. By citing this judgment.
My Lord, kindly see page 40. On the very first day, this.
That's right. No counter, nothing.
Paragraph 8, your lordship will see.
So all this will also get challenged now.
My lord. I am Devaraj Sahu. My case has been cited. And
I know, but if Devraj Sahu itself is decided on the very first day without notice, without opportunity for a counter affidavit, then all this will also get challenged, sir.
My lord, that is your lordship. That is also in Sitaram Bhoi's case. That is went to Supreme Court government. There also, your lordship, that case was dismissed. That judgment I have brought, your lordship. So nothing is to be adjudicated.
No. What happened to Sitaram Bhoi?
Sitaram Bhoi, your lordship, that has been also implemented. Your lordship, this is the judgment I have brought. That is Supreme Court.
I may be pardoned. I am in line. I am suffering from fever, my lord. Item 37, 38 may pray for.
Not like this, sir. Not like this in between. We are in between of some other matter. Just mute it, please.
That is order dated 6/8/2021. The state of Orissa has preferred SLP. Sitaram Bhoi is the respondent.
This means nothing. It's a whole problem. That 30th March was division bench or single judge?
My lord, that is single judge, your lordship. That is in my case.
Sitaram Bhoi, sir.
Sitaram Bhoi, your lordship.
What was that? Single judge? Sitaram Bhoi was single judge or division bench?
No, that is a division bench.
I don't know. Copy.
No. Where is that Sitaram Bhoi judgment?
My lord, that is division bench, your lord. WPC 15996 of 2019. That's what that division bench judgment is not with me.
Sitaram Bhoi's order, original order.
If you're agreeable, it can go back.
My lord.
If you're agreeable, it can go back. Let them file a reply. Because merely because SLP is dismissed will not mean that this judgment is correct. You know that judgment.
What is the ground taken in the writ appeal, your lordship? They have not. This is first time for admission. That is the problem.
No.
My lord.
Simple ground is no opportunity to file counter.
No, your lordship, no. In this case, my case, opportunity has been given, counter has been filed. Thereafter, your lordship. Your lordship, kindly see. Your lordship has not gone.
Come to page 14.
My lord.
What is that order number?
Your lordship.
Come to page 14, sir.
My lord, I am calling.
First November order. First November order.
My lord.
Which is the order number?
My lord. That is order number, your lordship will see 1.
That is 1 means what? Very first day. Order number 1 means what?
My lord. That your lordship,
very first day of hearing.
But your
where's the question of counter?
But your lordship, kindly see paragraph 5.
It came from transfer.
My lord, kindly see, your lordship, paragraph 5.
It came on transfer.
Oh, I see.
Mr. M. Balwantara, Lawrence Standing Counsel for
this was transferred from the OAT.
My lord.
Oh, I see.
Referring to your lordship, to the counter affidavit contended that appointment, this is that counter affidavit has been filed, rejoinder filed, thereafter your lordship
I see.
Order has been passed.
I see. So he's rendered service of more than 20 years.
My
That is
lord,
the ground.
more than 28 years, your lordship.
28 years.
My lord, 28 years. Date of appointment is in the year 1995 and is a sanctioned post. Has requisites qualification.
In paragraph C, my lord, kindly see, we have clearly taken a stand, my lord. There was no recruitment conducted.
Maybe, but for 28 years he's continued. If he continues for more than 20 years in a against a sanction post, somebody continues for 20 years. Then obviously Umadevi will get attracted.
My lord, may give me one chance. I will go through those orders my lord friend is relying upon.
No, that I'm aware of, sir. That's been referred to in the impugned judgment itself. Sitaram Boy has been referred to.
In the present case, my lord, we have taken a very categorical stand that no recruitment conducted. One.
No, all this was taken in Sitaram Boy also. Same.
And for regularization, my lord, 3 mandatory conditions.
But a person continues for 28 years here. Now he's continued for 28. At the time he went to the OAT, 20 years. You say the present writ appeal is preferred against an order dated 1st November 2021, passed by the single judge in writ petition civil, OAC number 912 of 2008. At the outset, it requires to be noticed that the said writ petition was transferred from the Orissa Administrative Tribunal to this court upon its abolition. Full stop. When the matter was taken up for hearing by the learned single judge, the counter affidavit of the present appellant was already on record. Full stop. The prayer of the respondent was for a direction to the state to regularize his services as clerk, as junior clerk cum typist in the District Consumer Dispute Redressal Forum, DCDRC, DRF. Full stop. Paragraph. It is noticed in the impugned order that on 3rd September 1996, the government had issued a letter to all the presidents of the DCDRFs to fill up class 3 and class 4 posts. Full stop. The present respondent was continuing as junior clerk cum typist against the sanction post since 14th December 1995. Full stop. By an order dated 22nd March 1999 in OGC number 673 of 1995, this court directed the state government to regularize the appointments of supporting staff of the DCDRFs. Full stop. It is noted that it is only 7 years thereafter that rules for regularization, for regular recruitment of the staff was prepared by the state government. Paragraph. Meanwhile, although the respondent was being given the regular salary as junior clerk cum typist and had rendered more than 20 years of service, his services were not regularized. Paragraph. The only ground on which the prayer of the respondent was resisted was that his appointment had been on an ad hoc basis, initially on a consolidated pay, and that his recruitment was not under the rules. Stop. The learned single judge noted that the respondent had been continuing against a sanction post and his services had been utilized for a considerably long period. Full stop. It took note of the fact that a similarly placed employee, Sitaram Bhoi, had approached the OAT with OA number 2424-C of 2001 and had succeeded in the said application, with the OAT passing an order dated 13th November 2018, directing the state to regularize the services of Sri Sitaram Bhoi. Full stop. The said order was challenged by the state in this court by filing writ petition civil 15996 of 2019, which came to be dismissed by a divisional bench by an order dated 30th March 2021. Full stop. Incidentally, the said order of this court was challenged by the state government before the Supreme Court of India in SLP Civil 11734 of 2021. And the said SLP was dismissed on 6th August 2021. Full stop. The learned single judge has also applied the ratio of the decision in Secretary, State of Karnataka versus Umadevi, AIR 2006 SC 1806, and Amar Kanti Rai, State of Bihar, 2015 8 SCC 265. Paragraph. Learned counsel for the respondent informs the court that the decision in Sitaram Bhoi Supra has been implemented by the state government by regularizing his services by memo dated 29th September 2021, issued by the Finance Department, Government of Odisha. Full stop. In fact, this has been taken note of in subsequent decisions of learned single judges while granting similar relief. And one such order is dated 3rd August 2022 of the learned single judge in writ petition civil 8207 of 2020. Paragraph. Considering that the respondent has already put in more than 27 years of service against the sanction post, the court sees no reason to interfere with the impugned judgment of the learned single judge, which is based on established precedents. Full stop. Secondly, with the government having accepted the decision of an identically placed employee, namely Sri Sitaram Bhoi, there is no reason to discriminate against the petitioner. Paragraph. For all of the aforementioned reasons, the court finds no reason to interfere with the impugned judgment of the learned single judge.
Time
Writ
limit
appeal is
for
accordingly
implementation.
dismissed.
Time limit for implementation because 28 days for
The
that reason.
impugned order of the learned single judge shall be implemented by the appellate state within a period of 8 weeks.
My Lord, may kindly keep the question of law kept open, man.
No. Certainly not, sir. Certainly not. Right.
I may be pardoned. Item number 37, 38, may kindly pray
Not
for
like
time.
this, sir. Not like this. You'll have to wait. You'll have to wait till the list is over. Yes.
My lord.
Item 54.
54, my Lord, 27-3, promotion during.
All right.
Item 55.
55, 56, I've given that order, my Lord. 25-4.
That matter, your lordships have already passed several orders. That I've given the copy for your lordships. Remittance, that is the matter of remittance.
All right. The impugned orders were passed on the very first day. Where is that similar order? Both matters.
55 and 56. Item 57.
57 promotion during pendency of vigilance case. 27th March.
Item 58.
58 minute 49. I'm giving the.
All right.
Item 59.
Promotion mark 27-3 during.
Item number 60.
60, 61, 62, 63, 64, my lord, the 25 for regulation. Same as item 53.
Are you appearing in these matters, sir? Just ask. Sir, these other matters are similar. The 60 onwards.
No.
You're not appearing because it's identical to that, what we passed in your matter. 55 to 6.
Up to 65, madam.
If you agree, we can send it all back, sir. You don't appear in those matters.
No, I'm not appearing.
All right. When are those coming up? 25th April. 25th April. All right.
Up to 65.
Yes. Up to 60.
Item number 66.
Item 66, your lordship has already issued notice in similar case and take to 21st August. So I am giving that for.
Hmm. 21st August.
Item number 67.
Lord, item 67, the impugned order is at page 23. Your lordship may see on the first date, the honorable single judge has virtually allowed the writ petition. I am just placing the operating portion of the order. Petitioner will forthwith approach opposite party number 2 along with the copy of this order. Said opposite party will inform petitioner regarding compliance with requisite formalities. Disbursement of ex gratia must be made within 8 weeks. That was the prayer of the petitioner in the writ petition for disbursement of the ex gratia. Without giving any opportunity for filing of counter affidavit, the Honorable Court on the first date has said that you disburse the ex gratia within a particular period. That is the only.
But by resisting it, he's not entitled to ex gratia or what? Ex gratia is immediate, no?
That is there, but
if it's a person who was drowned, if you have a scheme, you make the ex gratia payment.
But my instruction is that he is not entitled. There is some dispute and.
What is the dispute? Tell us. Even now, you can tell us. Why drag this man? He's grandson of a person who drowned.
Yes.
Why is he not entitled? It's an ex gratia amount. It's not a final composition. What is the reason for denying him? Ex gratia must be 10,000 or 20,000. What is it?
Yes, madam.
Why are you filing appeal for these kind of things? The impugned order simply requires the state government to grant an ex gratia amount subject to the respondent complying with all formalities. Full stop. The court sees no prejudice being caused to the appellant by the impugned order, particularly since it is not in dispute that the respondent is the grandson of a person who has drowned, and for which kinds of cases an ex gratia payment is all usually made. Consequently, there's no merit in the writ appeal. It is dismissed as such.
Item number 68.
The petitioner, applicant challenging the impugned order at page 26, my lord. 26. Ordering portion is at 43. 43. Paragraph 25. May I read?
Yes.
Consequently, this court finds merit in the plea of the petitioner that there were reasonable grounds for an apprehension that the selection of candidates was vitiated by bias. The writ petition is thus allowed. However, while allowing this writ petition, this court makes it clear that nothing noted in this judgment is meant to cast any reflection whatsoever on the eminence, credential, and achievements of the opposite party number 8 and other candidates. This court also held the OPSC and the experts invited for the interview in high esteem, and this may be treated as a standalone. aberration without any iota of erosion of this court's faith in their efficiency and integrity. It will be open to the appointing authority to appoint a fresh selection committee through a OPSC for the purpose of recruitment for the post of assistant professor of psychology in order to allow any kind of operation in the mind of the candidates.
Who are you?
I am the opposite party number 4 in the earlier writ petition appellant here. I am selected, recommended, and
But
appointment
because
order
of
was
bias,
issued.
sir. The whole thing was vitiated because of bias.
My lord, but that is not correct, because your lordship kindly turn to my writ appeal page 37. Page 37. Lordship, my lord, sorry, my lord. This impugned order, page 37. Got it, man? Lordship got it?
Yes.
Page 37.
Yes.
Actually, this starts from page 36. Just I am reading the 37 portion. The university within the specified date 22/10/2021, last date fixed for verification of the psychology disciplines, is completely demonstrates a case of extra favoritism. There was no relaxation of time notice uploaded in the website for knowledge of the other candidates.
You were not opposite party 8. You were opposite party number 10.
10.
So you had no such. There was no such allegation as far as you are concerned.
Yes, that is allegation also there.
What is your allegation as far as you are concerned?
My lord.
You come to that.
But on that ground, if that means I have selected and
no, what is the allegation against you, sir?
At the verge of joining this.
What is the allegation against you?
Against me, I am.
How come they not link the writ petition? What has happened pursuant to the impugned order?
My lord.
What has happened pursuant to the impugned order? Have they conducted the fresh selection?
No, my lord. Till that, neither that was challenged or conducted this fresh selection.
You are appearing for the
next item is mine, my lord.
Sorry?
Next item.
So
in that case, lord, I have been selected, I have been appointed. Without any notice, without including me, my appointment, my selection has been set aside.
Same impugned judgment.
Same impugned judgment. That my selection, lord, you can see page 83 of my brief.
No, but what has happened, sir, pursuant to the...
Nothing has been done, Lord, after impugned order, nothing has been done. And some of the Lord, selected candidates are also still working. In Ravenshaw University, some of staffs are still working.
3 assistant professors.
This, you are also working, sir, still?
No. At the verge of joining, stay order was. My lord, I have.
But the university has not come and appeal.
Another 2 writ appeals.
The Ravenshaw University, Utkal University, these people have not come and appeal. 3 universities.
Another 2 writ appeals are pending also.
By whom?
By the unsuccessful. Successful candidates. That is writ appeal 1073 of 2022.
Sir, 10?
Another is 1090 of 2022.
What is the first number? 10?
1073.
It is not listed even once. Not yet listed.
Listed earlier in the other bench of this honorable.
What was the order passed?
That is only adjourned. Your Lordship, kindly see page 15 of my ground writ appeal. 6.2. Page 15.
Page 15?
15. 1-5. Grounds of my writ appeal.
Right. Yes.
May I read?
Yes.
So far as allegation made against the present appellant being the opposite party number 10 in the above writ petition, that he was a student of PhD in Pondicherry University, whose guide was Professor Surendra Kumar Sai and not Dr. B. Rangia. Dr. B. Rangia was the member of the selection board.
So there was no ground as far as you're concerned then?
My lord?
So there is no ground as far as you're concerned. There is no ground of bias.
That was not taken into account in the
You're saying something in your favor, sir.
Again? This is my ground. They have not taken into account.
You're saying something in your favor. You're not understanding anyway. What is what you?
So far as I am concerned, my selection, I am in serial number 6, my lord.
All right.
I will also kindly see page 83. Page 83 of my brief. My serial number 5. There is no allegation so far as this petition is concerned. So far as present appellant is concerned, there is no allegation in the writ petition.
Ritu Patra.
Lords, I am Saswati Jena.
Saswati, 5, serial number 5. All right. You see, both these appeals you put together, both these appeals are directed against the common judgment dated 11th July 2022, passed by the learned single judge in a batch of writ petitions, including no, not in the against the judgment dated 11 July 2022, passed by the learned single judge in writ petition 7-39640 of 2021. Filed by the unsuccessful candidates. That is respondents 1 to 4 herein, who challenged the selection of the present appellants as assistant professors psychology pursuant to a recruitment undertaken by the Orissa Public Service Commission. Full stop. Paragraph, the ground on which the entire selection has been set aside. A selection of 9 candidates has been set aside. 9 candidates, including the 2 appellants herein, has been set aside is that the PhD guides of some of the candidates were part of the selection committee. Stop. Both the present appellants, however, point out that their PhD guides were not part of the selection committee, and therefore their selection could not have been set aside. Additionally, in writ appeal 1083 of 1083, yours is 1083, right?
Yes.
Of 2022, the appellant Shashwati Jana contends that she was not made a party.
Not a party also, yes, ma'am.
Not even made a party to the writ petition, and therefore was not heard before her selection was set aside. He further adds that she's as present continuing.
Well,
you're continuing as a...
No, I am not.
All right. You say notice returnable. May 2022. If no fresh selection has yet taken place, you know if a fresh selection has taken place?
No, it has not been taken place.
According to counsel for the appellants, no fresh selection has yet taken place. Full stop. In that event, the status quo as of date shall be maintained. See, notice, this one accepts notice for, one of you can accept notice for the state authorities. For state respondent number 5. Notice to the remaining respondents by registered speed post, returnable on the next day. All right.
Item number 70.
70 मतलब special list contractual.
71.
71 is promotion during pendency of this DP and vigilance proceeding matter. 27(3).
All right.
Item 72.
Learned SR has pointed out some defect, my lord. You lordship permit me, I will correct, but it is in a second copy. First time I come. Sorry, my lord, I will correct the defects. I will be removing.
You want 10 years salary when you remained on medical leave?
Pardon, Lord?
You could, you were on medical leave for 10 years.
No.
No.
No, my lord. Item 73, my lord.
We are called out 1154 of 2022. What we have called out now is 1154 of 2022.
Sorry.
None appears dismissed.
Item 73.
This is my lord.
All right. List on 11th April. No. Yeah, 11th April. Defects be cured in the meanwhile.
Item number 74. Item 74.
Password.
Item 75.
Wait, please, Your Lordship. There are some defects pointed out by the SR. I will remove it within a week.
All right. 11th April, defects be removed. In the
75, 76, 77.
All right.
Oh, bless me.
Item 78.
78 also removed the defect of 1 week time, my lord.
78, you put on 19th April. Defects be cured.
Item 79.
79, my lord, specialist matter.
All right.
Specialist.
Item number 80.
My lord, 1 week time to remove defects.
19th April.
Item
Be removed in the meeting.
81.
May I pray, my lord, kindly 1 week time to.
Say 19th April, defects be cured.
Item 82.
Special list में contract.
Item number 83.
Well, this is a matter challenge, order of dismissal of the writ application. And the order is like such, the matter is pending since 2000. This court finds there is even no admission of the matter for nearly 22 years. It is not desirable to enter in such a dismiss. But my lord, already 19 orders has been passed. Two parties, the petitioner number 2 and opposite party number 2, 3 in the meantime expired. They played in opposite party number 2 and 3, played a hide and seek with the honorable court and did not appear. So regarding their death, regarding their substitution petition, it was filed by the petitioner. So for the paper publication made, they have not appeared.
So it can go back. Who is for the state? Have you served a copy on them?
Yes, my lord. I will serve a copy.
You serve a copy, sir.
Yeah, my lord. I will.
See, this is dismissed only on the ground that the petition is pending since 2000. How can that be ground?
And 19 orders
the order dismisses the writ petition on the very first day only on the ground that the matter has been pending since 2000 and was not listed even once. To stop, this cannot be a ground on which the writ petition can be dismissed when it is not the fault of the appellant that the writ petition was not listed. Full stop. Accordingly, the impugned order is set aside and OJC number 6563 of 2000 is registered to the file of the learned single judge in the roster bench, where it will be listed for hearing on 17 July. The respondents herein will file their replies to the recited petition on or before 3rd July. Complete set of the paper books of the writ petition will be served on the standing counsel for the state, who is appearing today, positively by the counsel for the appellant by 3rd April 2023. The rejoinder to the counter affidavit will be filed with the appellant on or before 17 July. No further time will be granted for the above purposes. The learned single judge is requested to proceed with the hearing of the writ petition on merits and dispose it off as expeditiously as possible. Okay.
Item number 84.
May I please your lordships? This matter is about an interim application 1306 by 23 arising out of writ appeal 112 of 23, wherein your lordships has pleased to admit and issue notice awaiting counter affidavit and rejoinder, if any, by 14th September. In the meantime, my lords, after issuance of notice,
all right, you just say notice in this 1306 of 2023. It is alleged in the present application that the respondent Rourkela Steel Plant is cutting the cable network and damaging the equipment of the applicants.
My lord, I pray for a passover, my lord. I am appearing for OP number 123.
All right, passover. Right.
Oh, bless, my lord.
Item 85.
Miller's 76 days delay, Miller's. I have explained in Miller's.
All right, tell us what the matter is about.
Miller's, here is a case, Miller's. My impugned order has at Annexure 9, page 90, Miller. My dismissal proceeding has been stayed by this Honorable Single Judge, Miller, on the ground of at the stage of charge sheet, Miller. And no show cause has been filed on the ground that criminal proceeding is pending against the Miller's. Fact of the case is that Miller's the opposite party Miller's trapped by the CBI and RC case has been registered at West Bengal, Miller. Thereafter, Miller's have initiated dismissal proceeding and issued charge sheet.
They can go simultaneously.
Yes, Miller. That is allowed.
All right. Notice returnable.
Milord, I am for the respondent, Milord.
You can go on simultaneously, sir. That's a settled law. How can you stay one for the other?
Milord, by relying on
the settled legal position is both can go on together.
Yes. Milord, together, because Milord, both are based on same set of charges.
All right. All this is settled law, sir.
Milord,
one doesn't wait for the other.
Relying on the AIR 1999 Supreme Court.
After 99, there have been several decisions. You pick up one decision and therefore that's a problem.
Yes.
Tell me the other decisions.
Milord, Learned Single Judge has relied on two decisions, Milord. 65.
No. Mr. Mahanti will give you.
Milord, that is Milord's and 2004 Supreme Court 4127. Thereafter, Milord's recent decision is Milord's Yeah, 2019-4308.
Have you seen these decisions, sir? There are numerous decisions. Numerous decisions.
Supreme Court decision.
And this was on the very first day. No counter, nothing.
No, my lord. Second day, my lords, I pray for time, my lords, to file counter. The court is.
This is 1999.
99.
The first interim order was passed that no coercive action shall be taken against the petitioner. Thereafter, in second date, my lord.
Now, my lord, petition is joined in service, taken back into the service, and dismissal proceeding may continue, my lords.
Yes, yes. Yes. If you are agreeable, you participate in the disciplinary proceedings.
At the time of he was in jail.
Petitioner, my lord, discloses his defense in the disciplinary inquiry.
All that has been taken care of, sir, in all these decisions. All those points have been taken care of in all these decisions. The latest legal position is one doesn't stop for the other.
My lord. But if it is on same set of charges, my lord.
Sir, all these decisions are on the same facts. In all those cases, on the same set of charges, there's a disciplinary proceedings and this criminal proceedings. It's always on the same set of charges. It's not on different set. The whole question arises because it's the same set of charges.
Yes,
and the settled legal position is it can go on together simultaneously.
Yes, simultaneously.
That's a settled legal position. You say, notice, he accepts notice. The present appeal has been filed against an order dated 21st October 2022, passed with a single judge, allowing writ petition civil 25946 of 2022 filed by the respondent, disposing of it, and directing that during the pendency of the criminal case against the respondent, the disciplinary proceedings initiated against him by the present appellant, that is the Mahanadi Coalfields Limited, bracket MCL, shall remain stayed. Full stop. In issuing the said direction, the learned single judge has relied on the decision of the Supreme Court of India in M. Paul Anthony versus Bharat Gold Mines, AR 1999 SC 1416. And another decision
AIR 1965, my lord.
What is the cost title, sir?
Cost title, my lord, I'm giving. Tata Mills, Oil Mills.
Okay, Tata Oil Mills Company Limited versus Workman, AR 1965, SC 155. Paragraph. The counsel for the appellant points out that there have been subsequent judgments of the Supreme Court of India, including Karnataka Power Transmission Corporation Limited versus C. Nagaraju, AIR 2019 SC 4308, which have categorically held that disciplinary proceedings and criminal cases on the same set of facts can proceed simultaneously. Full stop. It is further pointed out that the appellant was not given a chance to file a counter affidavit explaining the legal position. Full stop. Indeed, it is seen that the impugned order is a cryptic one, which does not discuss the complete facts of the case and the settled legal position, as explained in several decisions of the Supreme Court subsequent to the decision referred to in the impugned order. Stop. Accordingly, the impugned order is hereby set aside, and writ petition civil 25946 of 2022 is restored to the file of the learned single judge, where it will be listed for hearing on 12 July. The present appellant will file its reply, Parav's reply to the writ petition, not later than 28th June and the respondent will file a rejoinder thereto, not later than 12 July 2023. Paragraph, the court is informed that in the meanwhile, the respondent has been taken back in service. No, has resumed service. Stop. It is directed that the disciplinary proceedings may continue, but will not be finalized till further orders are passed by the learned single judge. The writ appeal is disposed of the above terms.
Item number 86. Item 86.
None of this.
Item number 87.
In the instant case, the opposite party number 12 has encroached the forest land and on-forest activities were carried on that land. And there are, apart from that, there was no forest clearance. Without obtaining the forest clearance, the opposite parties number 12 has carried on
So
the
this matter
non-forest
was not
activities.
listed in the last 9 years. It has not been listed once, sir. A notice was issued in 2014, after which it's coming up now. It's better you file a fresh.
They have admitted in the counter that there was some illegality. It is the responsibilities of everyone, my lord, to protect the ecology and the environment.
No, but what has happened in the last 9 years? Why haven't you taken steps?
They have conducted an inquiry.
So why have you not taken steps? This is supposed to be PIL, correct?
Yeah.
You're not interested in the matter clearly.
It's not listed, my lord.
So you will also keep quiet. We've also been lawyers in the bar, sir.
Yeah,
We
my
don't
lord,
just sit back and relax.
We are filing.
In other high courts, they file applications for early hearing. The applications are filed. Even here, in the last 2 years, I don't think you have mentioned it even once before me. Have you mentioned it even once?
About this case?
You have not mentioned. Why? You follow the mentioning that is happening in this court? Every morning mentioning happens?
Mentioning.
And every mentioning I give a date? So that excuse also is gone. See, as a PIL petitioner, if you don't show interest, why should the court show interest?
Near about 10 years back, 9 years back,
9 years.
all these are, if any cause of action survives, he will go to NGT because all these are environmental hazards.
Petitioners filed this petition more than 9 years ago. And notice was issued on 20th March 2014. Full stop. Thereafter, the matter is coming up for the second time only today. Full stop. The allegation of the petition concerns violation of environmental norms by opposite party number 12 by raising construction on forest land. Illegal construction on forest land. Full stop. While replies have been filed by the State Forest and Environment Department as well as the central government, no reply has been filed till date by opposite party number 12. Full stop. The stand of the state government is that steps have already been taken by it to remove the unauthorized constructions. You have counterfeited, Mr. Monty. You say
Yes.
you've already taken steps.
Yes.
So what have you done?
The counter was filed in 2014.
Very good. An additional affidavit be filed by the State Environment Department to inform the court of the further steps taken in the matter. The affidavit be filed is 1 week prior to the next date. List on 17th May.
Item 88.
88 May, please, Mr. My Lord. Last week, the Lordship is directed the State Council to obtain instruction regarding the status of the land. When the Jalasaya is going to be filled out by the opposite parties, my lord, changing the character and natural character of the Jalasaya, my lord. And the pursuant to this, they filed that pursuant to the order of status quo is granted by this honorable court is remain in that intact, my lord. And my case is that Lordship kindly glance to the record of right, my lord.
No, you were to file an affidavit, Mr. Monty. What happened?
Yes, we have filed the affidavit with current letters report with photographs, everything.
Where is that?
This is filed on 20th March 2023 by one Binoy Kumar Patel, is the BDO Tarva. I have short copy on my other side.
Where is it?
It is not there. I will file.
Not there.
I will file a
Or
hard copy.
the affidavit state would have been filed by the state on
On
20th March 2023. Be brought on record. Copy thereof has been served on counsel to the petitioner. You want something to be done?
My lord, my grievance is that they are saying that plot number 115, which is Kisama Bondha Adi, is filled by pillar is being constructed. Now the when Jalasaya is situated over plot number 1196 to 1198. If the construction will be done on Bondha Adi, then automatically Jalasaya will be filled up. It will change its nature and character, my lord. My grievance is that, my lord.
We are not constructing on any Jalasaya land. It is on Adi land. He is saying that if we will construct there, then it will change its nature and character.
The Adi means, my lord, the four corners of the Bondha is said to be the Adi, my lord.
No. Adi means, yes, this is adjoining the Jalasaya. Adjoining the Jalasaya, there is also...
Adi means, my lord, the four side corner over which...
Your lordship may see the photograph and says how this will affect the...
My lord, what is called Adi in that language? My lord, Justice Satpathy will better apprise, my lord. The Adi means, my lord, the four corners of the Bondha.
No Jalasaya even there. That is the photograph.
Jalasaya is plot number 1196 and 1198.
Plot, that is the...
Construction is being carried on plot number 1195, my lord.
He is only relying on the record of right. But practically there is no Jalasaya. That your lordship can see the photographs. These are all developmental work. Why you are standing on the way?
No.
Because of some political rivalry between two groups.
It has not been sanctioned. It has not been sanctioned, my lord. They have admitted in the counter affidavit.
Can we file your rejoinder? All right. Rejoinder.
Under status quo is there. We are unable to proceed with the work.
Next date. The list on 15th May.
Obliged.
Interim order to continue, my lord.
Interim order to continue.
Obliged, my lord.
Item number 89.
Sure. Last occasion, your lordship wanted me to file an affidavit giving details. I didn't file it in the box because it may not come before lordship.
All right.
Your lordship kindly see fag X. I have filed an affidavit, my lord, Entire Miller's entire rehabilitation plot and quarters has been provided to
Here,
that.
here I have specifically
Only
indicated.
fourth
Sir, just a
portion has not been given
Sir,
because
just a minute.
some encroachment is there and litigation is pending here, Miller. So now, Miller's, my humble submission is that mining is closer to that villages, Miller.
Sir,
And
may I just
entire
indicate one thing?
as per
Sir,
their-
just a minute, sir. Sir, 102 persons are there who are going to be displaced. But they wanted that they have provided the land for the persons, which is a fallow land. It has not been filled up till now. No connection, forest connection, nothing has been done. But a portion of the land they proposed to allot in our favor has also been encroached, where several writ applications filed those encroachers.
Only
Where the interim
has
was
been
there, and
encroached,
the
that is
direction
still
has
Miller's.
been given to provide them 1 lakh each. And with due respect, Your
Lordship,
if Your Lordship direct anybody to make a field visit, Miller, it will clarify the position I have given the photographs.
Your Lordship, see my affidavit, Miller's tag X, Miller.
Kind of see the Annexure 7 series photographs.
Millers, I have given all the Millers, Your Lordship. See that Annexure C, B series Millers.
It is
Annexure
not at all
BC.
habitable.
Yes.
The lands they have shown is away itself and no way
Millers,
connected
near
with
the
the land
college,
that is
Millers.
allotted.
At Bolanda College side, Miller. They have wanted to stay there when the rehabilitation centers are in Miller's intervention of the district administration as well as the appellant also agreed that side, Miller. We have developed that side and some of the appellant are staying there also. Plus one college is there, Miller. Everything is there, Miller. I have also attached photograph, Miller. Now, Miller's that village is closer to mining. Anything happen, Miller's that that's why Miller's they have also provided quarters to stay there.
Sir, those quarters
See
have
the
been
photographs,
declared
sir. Have you seen the photographs enclosed?
Sir,
See
those
the
quarters have
affidavit
been
is filed.
declared unsafe.
Miller's 2-3% is staying there now, Miller's. Miller's because site is handed over more than 1 or 2 years, Miller's. Your Lordship, see Your Lordship that Miller's my affidavit, can see my affidavit.
See that Annex
Miller's,
Place 49.
they can shift there, Miller's. I'll develop whatever remains, Miller's. I'll immediately develop. I undertook
Page
that.
49, 50, if Your Lordship
Miller's
looks
authorized
at,
mining activities is total closed, Miller's. And for the national interest, Miller's, they may require to be shift, Miller.
sir, I have also given
I have
details
filed
that
also
there is no urgent need for them because they are.
Your Lordship, see that flag X, my affidavit, Miller's. Entire plot has been allotted. Only 4% has been not allotted because Nigamananda one
They are
college.
denying
Because
that.
they
Sir.
habitable.
Just see that para 14 of their affidavit. And then para 16.
Yeah, that is. I have admitted that 4% Miller's, 4 or 5%.
Read properly, sir. However, the said part is incorrect. Litigation are pending in respect to the land. Interim orders have been passed.
Only respect of 4-5 appellant Millers. We have Millers and that is litigation pending here, Miller. I have admitted in my affidavit.
4 persons have been allotted, no other person has been given.
Lordship, see my counter, Miller, see my affidavit flag X, Miller. I have given details, Miller's plot has been allotted, Miller, and quarter has been allotted, Miller, annexure B series, Miller. And Lordship, see 1 minute, Miller, your Lordship, see that affidavit, Miller, flag X, Miller.
No, but this recent
Sir, give me a
affidavit,
go by
you have
to
to
the
study
policy.
this affidavit, sir. What date is your affidavit?
Lordship, flag X, your Lordship, see that.
Sorry?
Flag X. 100-334 Millers the running page. Lordship, see that annexure A by series, Millers. Page 278. That is Miller's. Was categorically stated, Miller, your Lordship, see that affidavit. 232 Millers. My affidavit is running page 227, and I have annexed that allotment of plots, Miller, series of allotment plots, Millers at annexure 232. 2 Millers. All the appellant has been allotted, Millers, only except that admitted in affidavit, Miller. And thereafter, I have given a table, Millers, annexure B series. Lordship, annexure B series. I have given a table, Millers, and they are staying at quarters MCL accommodation also. And employment
to the
has been
affidavit
given,
filed
Lord. Everything
by
has
the
been given.
MCL. Mr. SP Mr. Lance, Senior Counsel appearing for the appellants, hands over in court today an affidavit of the appellants disputing almost all of the assertions of MCL in its affidavit. Full stop. Photographs have been enclosed with the affidavit to show that the
I'll file reply to that extent.
this situation in the of the plots at the rehabilitation site is such that it is inhabitable. And basic amenities such as drinking water, electrification, and roads have not been developed. Paragraph. The MCL is directed to file a further affidavit specifically addressing parawise the issues raised in the objection affidavit handed over in court today by the appellants. The affidavit will be filed before the next date with an advanced copy to counsel for the absence. List on. July.
In order to continue with that. Trying to forcibly evict them actually.
Everything they are
With
staying at
bulldozers.
quarter Miller. They are staying at quarter now, MCL accommodation.
No, quarters are dilapidated, sir. His report is there.
Where is an interim order? I don't think there's any.
Yes, sir. Interim order is there.
Where? At least the last 3-4 hearings, there's no interim order.
No, Your Lordship, every time, my Lord, I used to pray for Lordship and Your Lordship.
No, but we have not passed any interim order. Let it be like that. All right.
It is there, my Lord, with due
Give us the
respect,
date.
my Lord.
No. There is the date of the interim order. I don't see any. If there's been no interim order so far, because this is a petition of 2015, sir. And there is no interim order so far. All right.
Item number 90.
File a petition for revival.
Maybe, sir. Let's see.
Right.
Item number 90.
Item 90, my lord, last occasional, in 90, on last occasional, lordship are directed to give me the rule. I've got that rule, I can file it by open affidavit. If your lordship grants me 1 week time, I can file by open affidavit. The rule is with me, my lord. I can file it by open affidavit, my lord.
Where is that?
That I-
B.Ed qualification is mandatory.
Yes, ma'am. Lordship, you can find it that is the notification dated 30th July 1994. Lordship, similar 2I. That high school, upper primary school means any recognized or aided high school or upper primary which is not established and managed by the government of Odisha or union government or government of any state. Then your Lordship may see Rule 9. In order to be eligible to be considered for any post, a candidate have to satisfy the following conditions, namely, then a Lordship may turn to Appendix 1. Lordship can find it from page 217.
Yes.
Educational qualification for different categories. To your lordship, query regarding the trade.
Well, I need to go through the affidavit, my lord.
Not affidavit, this is a rule.
I'll supply that rule.
I need to go through the rule, my lord. Because 1974 rules, my lord, so the unaided during the aided period, my lord, if the untrained teachers can be
1994
appointed, my
rules,
lord. My lord.
Council for the SME department has placed before the court the Orissa Selection Board bracket Education Circle Recruitment Rules 1994. So in particular refers to Rule 2 bracket 1 bracket I, read with Rule 9 bracket G and Schedule 1 para 2, and submits that possessing a bachelor's B.Ed qualification from a recognized university was a mandatory requirement for being appointed as an assistant teacher, even in an unaided private school. Paragraph. Counsel for the appellant wants to examine the said rule and make submissions. List on 5th May. Not 5th, sorry. Not 5th, sorry. 3rd May. 3rd.
Oblige, my lord.
Pass over. Supplementary list passed over matter item number 2.
Despite a pass for unanimous. This was unanimous.
Item number 37.
You should be here now. Yes, Mr. Patnaik.
Item 37. Kindly unmute, sir.
They remove the dependent because I am suffering from severe cold and cough. 2 weeks time may kindly be given, my lord.
It's a 2020 matter, sir.
My lord, first time, my lord. Proper time only for 2 weeks. I will remove the defect and it will be listed and it will be hard, my lord.
Counsel, the appellant is stated to be unwell. List on 6th April. Defects be cured in the meanwhile.
My lord.
To attach the writ petition.
38 also same.
Copies of the writ petition. Concerned writ petitions. The respective writ petitions be linked. Yes.
Item 37 and 38.
My lord, both are.
Passed over matter item 74.
Obliged, my lord.
Item number 74.
Better pass one and a pass. All right, let's better pass one and a pass discussed.
Item number 84.
Item number 84, my lords, I'm appearing for Steel Authority, my lords, the respondents. Here notice was issued. Now I think, my lords, they have moved for an interim application.
That's right. They're saying that cables are getting cut off.
My lords, now let me just apprise, my lord, what the case is all about. To an open tender process, Jio, Bharti Airtel and others, they were allowed to come in. The petitioners, the appellants herein, my lords, they had not applied. So if my lords would see, that has been noted by the Honorable Single Judge in the impugned order. And if my lords would see the prayer in the writ petition also, which has not been annexed to the writ appeal, the prayer in the, if I hope, my lords, that version is there. Others, I'll give a copy of the writ petition.
No, we have.
My lord may kindly see the prayer. State of Orissa is not a party. Union of India is not a party. Now, my lord, may kindly see the first prayer. Order or direction of a suitable nature to all the opposite parties not to prevent the petitioners/LCOs of Rourkela providing cable television services to facilitate their trade freely in Rourkela town. Now, we are, my lords, the steel city. We are not concerned with any policy decision of the state or the Union of India. Second, my lord, second prayer, my lord, may kindly see. Direct the opposite party number 1 to issue appropriate direction to OP numbers 4, 5 and 6 not to take any coercive action against the LCOs petitioners and maintain an ethical business practice and develop a feel-good factor with LCOs as per pre-MSO's time. So these are all matters of policy. Now the tender was worked out, the selected bidders were functional. At that stage, they come before the court without challenging the tender process with this kind of a prayer. So if, my lords, these small local cable operators have to be protected, that is within the domain of the state. A PSU of the Union of India will not be able to come up with this kind of a policy. So the writ at the first place was not maintainable, my lords.
My lord.
Come this side, sir.
And the tender process has not been challenged.
My lord, the policy decisions cannot override the statute. This is actually guided by the Television Cable Network Regulation Act 1995.
But are you an authorized cable operator?
Yes, my lord.
Where is your authorization?
I have been, it was in original writ petition, my lord.
Shows.
I have been taken license.
Where is that?
They are all licensed. They've admitted that. They are all licensed holder and they were giving cable connection to all steel plants since 95.
Show us that, sir. Show us that. Because their contention is you are unauthorized cable operators.
They've admitted, my lord. They've taken license from post offices and the LCOs. No. There are two sets. They are LCOs, local cable operator, and they were.
No, you're not. They say you're unauthorized cable operators.
Now, if my lords would see, I'm sorry to interrupt.
Is there any privity of contract with the Steel Authority that you have?
No. Earlier they were taking. They have not.
What is that earlier, sir? Right now, what's your status?
Right now, they have taken tender.
What is your status right now? You tell us.
They were continuing till that, sir, without any.
What is your status, sir? Are you authorized or unauthorized? If you're authorized, show us the documents to show that you're authorized.
We are authorized, my lord.
Show us the documents.
So they are in the original writ petition, my lord.
My lord, if I may show, my lord, page 22 of the writ petition annexure 3. That was the genesis of this dispute. Applications were called for. Out of that, 3 people applied. They were selected. Now, that process was not challenged at all by them.
No, they participated.
No. They didn't participate, my lord. So this writ was not maintainable at the first place. But with great difficulty, interim order was granted. We got it vacated. Then, my lords, this order was passed. There's an observation by the Honorable Single Judge that you may consider the grievances later on. There is no infirmity, my lords, in this order. And there was a threadbare argument. All the judgments have been shown. There's nothing in this. This writ should not have been entertained from the day one, my lords.
Yes, sir.
In writ petition also, we have got a favorable order. In future, they can take original writ petition.
So why have you filed an appeal then?
No, they have not had the representation in writ petition.
So the order in the writ petition is not against you then?
No, my lord.
You have filed this writ appeal against that order, sir. You have filed this writ appeal against an order in the writ petition. Now you say the writ petition order is in your favor.
My lord, it is not in our favor. It is partially they have admitted and they have directed to consider the future.
Anyway, as and when that happens, you can assert your rights, sir.
No, even I was directed by the writ court to file representation in earlier writ petition, which has been rejected without hearing us.
That's a separate cause of action.
So till the writ appeal is final disposal of, my lord, they are small petitioners. They are small LCOs. They are continuing till date.
No, where's the question? There's no interim order. Writ petition has been disposed of. It's been dismissed, in fact. The impugned order dated 5th December 2022 of the Learned Single Judge has dismissed the appellant's writ petition. civil numbers 14995 and 15600 of 2022, whereby directions had been sought inter alia to the Steel Authority of India Limited (SAIL), Rourkela, not to prevent the appellants from providing cable television services in Rourkela town. Paragraph. Mr. Gautam Mishral and Senior Counsel appearing for the Rourkela Steel Plant (RSP) of SAIL informs the court that RSP had issued a circular dated 28 October 2021, inviting applications from interested individuals for providing cable TV or internet services in the Rourkela township on license basis for a period of 36 months. Full stop. It is pointed out that although certain other entities and individuals had applied pursuant to the above circular, the present appellants had not. Full stop. Consequently, there was no privity of contract at all between the present appellants and SAIL for the aforementioned prayers in the writ petition to be even entertained. Paragraph. Nevertheless, court notes that in the impugned order, the learned single judge has observed that if there is any fresh bid invited in future, RSP may consider the case of the appellants. Full stop. Paragraph. Having heard learned counsel for the appellant as well as learned senior counsel for SAIL, the court is unable to find any error having been committed by the learned single judge in rejecting the writ petitions on the ground of maintainability. Full stop. Indeed, the prayers in the writ petition were in the realm of the policy of SAIL, which was certainly not amenable to judicial review. Full stop. Consequently, no grounds are made out for interference. The writ appeal and all applications are hereby dismissed. The next date is cancelled.
We are grateful.
All right.
Specialist for orders, item number 1, W777 of 2021.
May it please the Lordship. But here we are concerned with regularization of data entry operators. Let me tell you, Lordship, briefly what this case is all about.
Yes.
The government, my lords, in 2006 November, created 600 posts of data entry operators, come assistants, to prepare distribution of land passbooks. Land passbooks, my lord. And that was for a period of 6 months. Now, this was a specific project and the remuneration was to be rupees 4,000. Now, my lord, unlike data entry operators in the secretariat and in your lordship's court, my lords, there are no rules, nor are there cadre posts of data entry operators in the districts. Both the secretariat and your lordship's rules, my lords, they have a procedure for appointment. There are qualifications, graduation in case of your lordship's court, intermediate in case of secretariat, followed by an written examination of IVS, etc., etc. Here, all was not there. And because there is no corresponding cadre post, there is also no recruitment procedure prescribed. Now, what the learned single judge holds is that there is a circular of 17/9/2013 which says that in the event posts are created by abolishing of existing posts or posts are created to strengthen the departments and the recruitment procedure has been followed, ORV has been followed, on completion of 6 months, of 6 years, you shall be automatically regularized. Yeah. This is what we are challenging. And this case is Patitapavan Das. And Patitapavan Das has been followed in several judgments which are here before your lordships, saying that because you have completed 6 years of service, wholly unconnected with data entry operator, subject to correction by my learned friends, my lords, you are covered under Patitapavan. Am I clear, my lords?
Subject to correction, it was agreed by both sides. When all other cases were taken up, it was agreed by both the sides that the case is covered by Patitapavan.
That's all right. We will have a look at it. Agreement or otherwise, we will have to see whether Patitapavan. So, my lord, my humble submission is, if your lordship just have a look at just a few paragraphs of the judgment and then I'll deal with the facts.
Yes.
I am trying to make an endeavor to use a tab. So I may not be able to assist your lordship the normal way I went.
All right.
Kindly come to page 46 of the writ appeal.
Right.
My lord, sir, paragraph 2 minutes.
Yes.
The factual matrix of the case, in nutshell, is the government of Orissa and the Revenue and Disaster Management Department, by letter dated 24/11/2006, conveyed the sanction and creation of 600 post of data entry operators cum assistants to be engaged in different districts by the collectors to render assistance. Kindly note, my lord, to render assistance for preparation and distribution of land passbook. My lord, what is a land passbook? My lord, suppose I own some land, I will be given a document to say that, look, this is the land you hold in this area and this acreage. For a period of 6 months, with a remuneration of rupees 4,000 per month, as per the eligibility criteria and manner prescribed therein, so far as Cuttack district is concerned, the number of data operators prescribed was 48. I will show that document to your lordships in a while. Let me complete with this judgment. 9ly 2.1 now. In order to fill up such posts, an advertisement was issued in the newspaper and through notice in the district office of Cuttack, and request was made to the district employment exchange Cuttack to sponsor the names of candidates having graduation, post-graduation with so-and-so, so-and-so, for the purpose of being shortlisted for being appointed as data entry operator cum assistant in various tahsils of Cuttack district. Consequently, the petitioners along with 150 candidates were shortlisted and they were asked to appear in the written test. Thereafter, a computer test was held on 31st of January 2008 in the conference hall of so-and-so by issuing call letters to the individual candidates. On 24th of January 2008, by the ADM cum vice chairman, district level so-and-so. Now, my lord, this next line is very crucial. By following due procedure of selection, the petitioners were selected and also appointed. Your lordship may only note three things, my lords. This is a verbatim quotation of the writ petition. A word in paragraph 5, page 5 of the writ petition. Your lordship may only note it. I will show it later. Which was refuted by us at para 10 of the counter, page 7, and writ appeal, para 7, page 10. Your lordship may now see the next finding, Millers, is at para 7 of the judgment, which is page 66. My lords have it, Millers.
Yes.
My lords have paragraph 7, page 66.
Yes.
On a careful consideration of the rival contentions and on perusal of materials available on record, this court finds that the petitioners having requisite eligibility criteria, your lordship may only note that, minutes, and on being duly selected through a transparent written test conducted by the selection committee headed by the ADM and had been appointed against sanctioned posts and continued to work for more than 6 years without benefit of protection of interim order of any court or tribunal. Therefore, they are deemed to be regularized in so-and-so with allowance permissible from time to time as per GA resolution number 17/9/2013 by issuing formal order of regulation in their favor, particularly when such benefits have already been extended to similarly circumstanced employees of other departments in 11 series. Well, my objection is to the following. They did not have an eligibility criteria. They were not selected as per any transparent procedure. They were not appointed against any sanctioned post or vacancy. And furthermore, my lords,
where is that? Let's read your specific government in your counter affidavit.
My lord, in my counter affidavit, your lordship sees.
Because we have the counter affidavit with us.
Your lordships have it, my lords?
Yes.
Kindly turn to my lords, counter affidavit, para 10, page 7.
Right. The running page.
Para 10 page. It's running page.
Page 63 of that.
My lordship will have it at running page 63.
Right.
At the foot of the page, minutes. That this deponent stoutly denies the amendments made in para 5 of the writ petition, and the petitioner is put to strict proof of the same, in as much as neither any advertisement was issued nor any written test held as stated in the writ petition.
Let's see the rejoinder to this.
And the rejoinder, your lordships will see, Millers.
There is no para-wise specific.
There is no the rejoinder, my lord, starts at page 80. And subject to correction by my learned friend, my lords, there is no reply to my contention in para 10.
Yeah, para 16.
Yes, my lord.
They simply say amendments made in 7 to 12 of the counter affidavit are equally
misconceived and misleading. I will show you lordship the documents. So the documents will speak for themselves.
So according to you, no written test was held.
I will show that to your lordship. I'll show that to your lordship. And in any event, my lord, it's my case.
that 17/9/2013 has no application to the facts of the present case.
Let's read that resolution.
I'll show that.
Page
There is
72.
one other point which the learned single judge has held is that in any case Umadevi applies because 10 years have passed. So therefore, these are the two things I have to satisfy your lordships.
No, but before we do that,
yes, my lords.
The learned single judge noted,
yes, my lords,
a chief secretary's minutes.
Chief secretary minutes has not been lordship. Learned single judge says chief secretary minutes has.
They are not applicable to the.
They are not applicable to the facts of the case.
Because they provided a 79.
Page 48 of annex, that flag white.
Now let us see the judgment.
No, it's been quoted. That is para 2.2 of the judgment.
My lord.
It says government is contemplating to frame policy.
Contemplating. It did not arrive at a decision. On the contrary, my lord, there is another document which I'll show you, lordship. But let me tell you, the lordship, state 79 straight away. Is that right? 79. My lords, I have given a compilation to your lordships. It must be online also.
Yes.
Kindly see page 4 of the compilation. My lord, before your lordships go to the compilation, would your lordships be graciously pleased to see page 1 of my compilation? Let us see what was the government decision in the first place.
Right.
This is 24/11/2006. My lords have it, my lords?
Yes.
Engagement of data entry operators come assistance for preparation and distribution of land passbooks on contract basis. I am directed.
List of dates. Sir, yeah, list of dates.
No, I'm referring to the document. I'm referring to 24/11/2006. I am directed. My lord, your lordship may see the subject, my lord. Engagement of data entry operators come assistance for preparation and distribution of land passbooks on contract basis. I am directed to convey the sanction of 600 posts of data entry come operators come assistants who are engaged in different districts to render assistance for preparation and distribution of land passbooks for a period of 6 months at the rate of rupees so and so per each per numbers indicated in the enclosed statement, which is based on the number of so and so, so and so. So, my lord, therefore, temporary post, fixed term, fixed purpose, fixed remuneration. While conveying the sanction order to the respective collectors, the following aspects may be kept in mind. The recommended qualifications would be matriculate. Lordship may kindly note that. Would be matriculate. With knowledge of computer operation, the temporary collection staff who were engaged earlier in collection work may be given preference. If the required number of data entry operators come assistants are not available in the district, after exhausting the above condition, means the temporary collection staff. And wherever service providers are available, the collector may take their assistance to fill up the vacancy. So therefore, first exhaust the temporary collection staff, then go to service provider. If you fail, if service providers are not available in the district, the collectors are free to engage them from the open market. The engagement orders will be issued by the respective collectors, specifying clearly that the date of engagement clearly for a period of 6 months. Disengagement is automatic on the expiry of the term and no termination order needs to be issued again. A copy of the sample format, my lord, lordship may see the last paragraph. The necessary instructions to the respective collectors may be issued in the above line, so and so.
So this did not require any written test to be held.
Nothing. Kindly look at the next document. This is the one, my lords, which talks of a written statement. This is 24th of January 2008. This is one of the letters issued in Cuttack, and let me read it slowly. It is to intimate to you that DISC, nodal agency of the district to support preparation and implementation of information management plans by different departments and other organizations in the district, has decided to have a panel of computer professionals so as to facilitate their engagement. Kindly note, my lord, as and when required in the district as service provider. This is the document which has been relied upon to say that there was a selection process followed. For this purpose, a computer test is going to be organized. My lord, for what? For engagement of a service provider. For this purpose, a computer test is going to be organized on so-and-so in the conference hall of so-and-so. Your name has been shortlisted from the district employment exchange. You are therefore requested to come for the said test on January so-and-so at the conference hall, along with Xerox copies and certified copies of relevant documents like HSC examination certificate, graduate, postgraduate, DCA so-and-so, so-and-so. You are also requested to come with DIP board and clipboard. It is pertinent to mention here that this letter/test cannot be claimed as a job offer or any assistance, assurance for future employment engaged by the undersigned. My lord, this is the letter.
Yes.
Except, my lord, Patita Pavana Panda, Patita Pavana Das, no other writ petition encloses such a document. And in any event, my lords, this was a document which says that we are looking to engage service providers. Am I clear, my lord? The line is very clear. Now, kindly, now your lordship wanted to, so 17.9. So let us look at 17.9 in the background of this. And this is what the learned single judge relies upon. Regular appointment of existing contractual Group C, Group D employees who are not holding any post in contravention of any statutory recruitment rules made under the proviso to Article 309. The policy regarding regular appointment of following categories of contractual Group C, Group D employees appointed under the state government was under the active consideration of government for some time. This has nothing to do with data entry operator. Contractual appointment/engagement, kindly see this is important, made against contractual posts created with the concurrence of the finance department. Well, next slide is important. On abolition of corresponding regular posts. So therefore, if the finance department creates a post by abolishing a corresponding regular post, or contractual appointment made against contractual posts created with the concurrence of the finance department without abolition of any corresponding regular post in case of new offices or for strengthening existing offices. So this is second. So therefore, one, posts are created on abolition. Posts are created without abolition but for strengthening. And third, most critical, following the recruitment procedure prescribed for the corresponding regular post and the principles of reservation of posts and services of different categories. So not only posts have to be abolished, posts to be strengthened in departments, but also it must be recruitment procedure has to be followed of corresponding regular posts. The question here therefore arises, my lords, whether there are any corresponding recruitment procedure for a regular post. Since districts have no posts, no regular posts, there is no procedure for recruitment prescribed. So my humble submission to your lordship is this, that this being critical, 17/9/2013 has no application. Firstly, my lord, for the reason that posts have not been abolished. Secondly, for the reason this is not to strengthen any existing post, any existing office. This is a short time. Land passbooks have to be created, that's about all. And what is very vital is, since there are no corresponding regular posts, there is no recruitment procedure which has been followed to appoint these persons. Now, I try to look around, minutes, for regular posts of data entry operated in other organizations. In districts, it's are not there. Secretariat, it is there, and I'll show you, lordships, what the rules are. And your lordship's court also has a rule. So my submission to your lordships, my lords, because of these preconditions, 17.9 has no application at all. Your lordship may now see page 5. Lordship may see 2 minutes. Regular appointment of the above category. Lordships have it?
Yes.
regular appointment of the above categories of contractual employees shall be made on the date of completion of 6 years of service or from the date of publication of this resolution, whichever is later, in order in their names appear in the gradation list prepared under paragraph 1. The period of 6 years shall be counted from the date of contractual appointment. So this is the notification, my lord, circular, on the basis of which this writ petition has been allowed. So therefore, in my humble submission, if I have to fall under 17 September, I have to satisfy your lordships that these posts have been created by abolishing posts. The posts have been created for strengthening departments. And thirdly, most importantly, there must be a regular recruitment procedure which has been followed. And your lordships have seen page 1 and 2, nothing of that kind has been followed. So in my humble submission, my lord, 17.9 has no application to the facts of the present case. Now, my lord, 17.9 has to be read along with, my lords, 16.1. 1 second, let me.
2014.
I am trying to learn something.
Should we continue after lunch?
Yeah, lordship. I hope I have not done badly till now. 2 is, since there is no corresponding regular
Recruitment
post,
procedure. Yeah.
there is obviously no recruitment procedure prescribed.
Correct.
Now, your lordship may see, in other words, no contractual appointee shall be eligible for regular appointment as per the aforesaid resolution unless the mandatory eligibility conditions described above are fulfilled. Now, your lordship may read para 2. If, apart from the contractual employees fulfilling the conditionalities elucidated in para 1 above, there are other categories of contractual employees engaged with or without creation of posts of the concurrence of finance department without following the relevant recruitment reservation rules. These are also contractual employees. There are also contractual employees engaged on outsourcing basis through service providing agencies. These contractual employees are not eligible for regulation as per the aforesaid resolution.
Right.
So therefore, there are 3 categories. Either you have been appointed following the due procedure on abolition of posts, or number 2, you have been appointed without following the procedure, and number 3,
Outsourced.
Outsourced. So 1 qualifies,
2 and 3
don't qualify. I'm grateful to your lordships. And then para 4 may not be very relevant, my lords. Would your lordships now see 12/11/2013? That your lordships will get, my lords, at page 8. My lord, what happens to the rest of the candidates who are available? If my lords kindly turns to page 8, my lords, in exercise of powers conferred by proviso to Article 309 of the Constitution of India in supersession of the respective recruitment rules.
This is the regularization after 6 years.
Grateful. So, my lord, what happens is, my lord, what this says, that persons who are not covered under 17/19/2013 read with 16th of January 2014, what is going to happen to them? Your lordship may see rule 4, page 10.
Yes.
Categorization of existing contractual employees. For the purpose of these rules, all contractual appointments made prior to the commencement of these rules shall be classified into 2 categories. 1, contractual appointments engaged made against contractual posts created with the concurrence of the finance department. Now, next word is very critical. Without following the recruitment procedure, including ORV and rules regulating recruitment for regular posts. So there could be some people who have not been appointed following the recruitment rules regulating the appointment of regular posts. Am I clear, my lords? There will be 1 category also. And 2, contractual engagements made through manpower service. That is outsourcing. So what this has for these 2 categories, your lordship may see paragraph rule 8 at page 11. My lords have it.
Yes.
Special provisions for different categories of existing contractual employees. The contractual employees belonging to category 1 and the persons provided by manpower service provided under category 2 who shall be less than 45 years of age and shall have completed at least 1 year of continuous service in case they apply for recruitment under sub-rule 1 of rule 5 of the group C, group D posts shall be allowed relaxation of upper age limit for entry into the government service, provided they satisfy all other eligibility criteria for the post as laid down on the relevant rules. 2B, they should be allowed 1% extra marks on the total marks of examination for each completed year of continuous service, subject to a maximum of 15%, which shall be added to the marks secured by them for deciding on merit. So therefore, my lords, if you have come through a service provider, if you have come through without following the recruitment rules, there is some benefit for you in the form of relaxation and weightage. My lord, this notification.
And then such people will get the benefit of regularization after 6 years.
They will straight away get it.
After 6 years.
No, not 6 years. Because what will happen is, once they compete with the weightage and the relaxation, they will get into normal post minutes. Now, this notification has been repealed in 2022.
Correct.
Now I'll tell you, Lordships, where does the petitioners get the relief? Kindly see, minutes.
What is that order?
Close to it. 1 second. Would your Lordships now kindly turn to minutes, page 17. This is 24th of February 2016. My Lords, have it, minutes?
Yes.
Creation of 692 posts of junior clerk in lieu of abolition of 692 corresponding regular vacant posts in survey settlement organization of the Board of Revenue. So therefore, what they do, milords? They create 692 posts by abolishing 692 corresponding regular posts. So therefore, regular posts are now created and by virtue of this. What your Lordships will see, milords, just after that table, the post so created is required for regularization of data entry operator engaged on contractual basis in tahsils of the state by following the relevant recruitment rules and the provisions of the ORB Act as per stipulations contained in so and so, so and so. Now, milord, this was modified at page 19, 3 months thereafter. And if my lords kindly turns to page 19 now. My lords have it, minutes?
Yes.
Creation of 692 posts of junior clerk in lieu of abolition of 692 corresponding regular vacant posts in survey and settlement organization under Board of Revenue Odisha, Cuttack. In partial modification of the order of the government issued by order dated so and so, this was the previous document, I am directed to convey the sanction of the governor to the creation of 692 posts of junior clerk. Kindly note, not junior clerk. In 317 tahsils, in each tahsil, and 01H in 58 subdivisions in lieu of abolition of 692 posts, vacant post survey settlement so and so. Consequently, the approval of the governor for abolition of the aforesaid 692 posts is hereby conveyed. The newly created posts should be built up on contractual basis initially following the recruitment rules and the provisions of the ORB Act as per the stipulations contained in GA department number so and so, and conditions of service shall be governed by the aforesaid notification of GA. This has been concurred. So therefore, my lord, these posts are now required to be filled up under the Odisha Ministerial Services Rule 2019, and that is at page 44. Would you lordship first see Rule 36, page 36?
Yes.
My lords may see rules at page 36. So this was the original rule. These rules may be called the Odisha Ministerial Service Method of Recruitment to the post of junior clerk in District Office, Rule 1985.
2E, sir.
If your lordship sees 2E, my lord, post means post of junior clerk in the district offices. And my lord, these lays down the eligibility of candidates is page 7, is para 7, Rule 7. Standard of syllabus and examination is Rule 10. Holding of examination is Rule 9. And so on and so forth. My lord, this is amended by virtue of page 44. My lords have page 44, my lords?
Yes.
This is the 29 rules. So these are the two rules. so far as district offices are concerned. In exercise of powers conferred by proviso to Article 309 of the Constitution in supersession of so and so minutes, instruction except as respect things done omitted, the governor of Odisha makes the following rules. Now here, your lordship may see, my lord. 2C, if my lords kindly sees, cadre means the district cadre comprising of district offices and subordinate offices thereto, functioning under different departments of the government. Your lordship may then see 3, constitution of service. The service consists of the following posts: junior assistant and senior assistant. Method of recruitment is paragraph 4. Recruitment to the post of junior assistant shall be made by way of direct recruitment through competitive examination, promotion from amongst Group D employees. Appointment to senior assistant shall be made by way of promotion from the junior posts. Then 5 is reservation. 6 is recruitment procedure. My lordships have minutes. So there's a whole chapter on how they are to be admitted. Now the question is that 692 posts are today vacant. Your lordships can always say that the weightage which was available under that rule, which got superseded, namely, you will get a relaxation of age and you will get marks for the numbers of years of service, and they can compete here for the 692 posts. Unless the learned single judge did not consider this. But to get the benefit of 2017, they have to satisfy your lordships that posts were created by abolishing posts. Posts were created for strengthening of the office. There was a recruitment procedure, but I am not going to worry at all. There was a recruitment procedure for similar posts.
There are no similar posts.
There are no similar posts. Your lordship may just have a look at a few judgments. Kindly see, my lord, page 57. This is State of Gujarat and others versus R.G. Pathan. My lords have it, my lords?
Yes.
This is page 57. Would your lordship be kindly pleased to come to page 60? Paragraph 6.
Yes.
At the outset, it is required to be noted that the respondents herein, original writ petitioners, were as such appointed in temporary project, which was created only for the purpose of rehabilitation pursuant to earthquake for post-earthquake redevelopment program. All of them were initially appointed for a period of 11 months on fixed salary, which came to be continued from time to time till the requirement in a particular project/unit, project implementation unit. However, as the said unit was required to be closed, which as such was a temporary unit, instead of putting an end to the services of the respondents, the state government thought it fit to transfer and place them with the Indian Red Cross Society. At this stage, the respondents approached the High Court and challenged their placement with the Indian Red Cross. Your lordship may now see para 10 over the page.
Yes.
The division bench has also not appreciated the fact and or considered the fact that the respondents were initially appointed for a period of 11 months and on a fixed salary, and that too in a temporary unit, project implementation unit, identical to our facts, my lord, which was created only for the purpose of rehabilitation pursuant to earthquake or post-earthquake redevelopment program. Here it was for land passbooks. Therefore, the unit in which the respondents were appointed was itself a temporary unit and not a regular establishment. The posts on which the respondents were appointed and working were not sanctioned posts in regular establishment. Your lordship may kindly note, my lord, these were temporary posts, and these, here the lordship say sanctioned posts in any regular establishment. I'm heavily relying on this line. In regular establishment of the government. Therefore, when the respondents were appointed on a fixed term, on a fixed salary, in a temporary unit, which was created for a particular project, no such direction could have been issued by the division bench of the High Court to absorb them in government service and to regularize their services. the High Court has observed that even while absorbing and or regularizing the services of the respondent, the state government may create superannuary posts. Such a direction to create superannuary posts is unsustainable. Here, my lord, if the learned single judge order has to be implemented, then we have to create these posts now. Such a direction is wholly without jurisdiction. No such direction can be issued by the High Court for absorption regulation of employees who were appointed in a temporary unit which was created for a particular project, and that too by creating superannuary posts. Your Lordship may see para 13. Now, so far as reliance placed on the decision of this court in Umadevi and the subsequent decision in so-and-so, relied upon by the learned counsel appearing on behalf of the respondent is concerned, none of the aforesaid decisions shall be applicable to the facts of the case at hand. The purpose and intent of the decision in Umadevi was to prevent irregular or illegal appointment in future. 2, to confer benefit on those who had been irregularly appointed in the past and who have completed for a long time. The decision of Umadevi may be applicable in a case where the appointments are irregular on sanctioned post. Your Lordship may kindly note that, my lord. Sanctioned post in a regular establishment. Here you may say finance had sanctioned it, but it was not on the regular establishment. The same does not apply to temporary appointments made in a project/program. Your Lordship may then kindly see, my lords. Leave it. Lordship may see page 117. This is University of Delhi. Your Lordship may see paragraph 16, 17, and 18. Paragraph 16, my lords, will get at page 125.
Yes.
The contract employees, my lords have it, my lords?
Right.
The contract employees in the present case cannot therefore claim any relief of regularization in terms of paragraph 53 of the decision of Umadevi. The rejection of that petition by the single judge of the High Court was quite correct, and there was no occasion for the judgment bench to interfere in the matter. It is true that on the day when the judgment of Umadevi was delivered by this court, the contract employees had put in about 3 to 4 years of service. But as of now, most of them have completed 10 years of service on contract basis. Though the benefit of regularization cannot be granted, a window of opportunity must be given to them to compete with the available talent through public advertisement, a separate and exclusive test. What was argued, please have a separate test for us. A separate and exclusive test meant only for the contract employees will not be an answer, as that would confine the zone of consideration to employees themselves. The modality suggested by the university, on the other hand, will give them adequate chance. Same as the rule 8 of the rule 8, which was earlier there. Then your Lordship may kindly have a look at. We therefore direct that all the concerned contract employees engaged by the university be afforded benefits of 6(7) of the affidavit dated so-and-so, the benefit of wage relaxation as contemplated in para 6 of the affidavit without any qualification must be extended to all contract employees. In modification of para 7, those employees who were engaged in the year 2011 be given the benefit of 10 marks in the ensuing selection process for every additional year that a contract employee had put in, benefit of 1 mark subject to ceiling of 8 additional marks. So this is weightage. Your Lordship may see one more judgment, my lords, and that is at page 128. My lords have it, my lords?
Yes.
122, correct? This is my lord's judgment sitting in Delhi High Court, para 11, 12, 13. May I read para 11, my lords?
Yes.
As far as the appellant's case is concerned, there is no scheme under the DOPT scheme for considering his claim for regularization. As already noted by the opposite parties in the impugned order and so, none of the applicants similarly placed as the present appellants have been regularized. The important fact to be noted here, as there was no sanctioned regular post against such regularization could be ordered. My lord, I'm heavily relying on two lines here. One, your lordship say, my lords, that similarly placed applicants have not been regularized. In annexure 11 series to the writ petition, my lords, they have filed regularization of data entry operators who were working in different departments of the government. My lord, am I clear, my lords? Government, because Secretariat had a rule for themselves. Districts never had any rule. And what your lordship further held is the important fact to be noted, as there was no sanctioned regular post against which such regularization could be made. Your lordship, I kindly see Nihal Singh was relied upon, that sanctioned posts don't fall from heaven. Your lordship says at para 13, it is not known whether Nihal Singh was a state of Punjab. Any scheme similar to DAPT scheme 1993 was available for implementation. In any event, but I'm relying on this, in any event, no mandamus can be issued to the opposite parties to frame a further scheme, ignoring the requirement for having sanctioned post for that purpose.
Yes.
My lord, there is one-page order which your lordships have recently delivered. My lord, may kindly turn to page 3. This is the model format which was referred to in annexure 1. I so and so, my lordships have it.
Yes.
I so and so, son of so and so, who has given an offer of contract appointment for so and so per month, is fully aware that my appointment is purely temporary and on contract basis and can be terminated any time without any notice or resignation. I am fully aware that my continuance of the said post is contingent upon extension of the said post by the finance department subject to my satisfactory performance. I would hereby give an undertaking in future, I shall not claim. Now your lordship may see, my lords, relying on a similar matter, your lordships at page 10. My lords at page 10.
Yes.
WPC 3271. The order of engagement of the petitioner dated so and so records an undertaking that engagement is purely on contract basis, can be terminated any time. He shall have no claim for regular appointment. Petitioner does not appear to have accepted the above order under protest or even tried to resign from this undertaking. Consequently, no mandamus can be issued. So therefore, my submission is, lords, they are not covered under the resolution of 17/9/2013, read with 16/1/2014. And my lords, there is posts available of junior clerk. They can always appear and participate in those examinations. And your lordship may give them weightage, as was done by Justice Lalit Milot in that Delhi case. I'm deeply obliged to you.
They are still continuing in service though.
They are continuing because of orders passed by lordships.
Since 2020, status quo has been ordered.
Yes.
So they are continuing.
They are continuing. But it is open for them to, just let me finish. It is open for them.
No, but they got engaged in 2006. When did they get?
2008.
So they've completed 15 years now.
There were interim orders passed. They have not passed any examination. They have not followed any procedure for appointment. They can very well compete with these 692 posts which have now been created. And if they, with the weightage, if they are good, they will get it.
No, they were initially engaged against
for 6 months.
But against sanction posts.
Against sanction posts, my lords, for 6 months. Would your lordship see page 1 of the compilation?
Right.
If your lordships kindly sees, my lords, page 1 of the compilation.
So those sanction posts don't exist anymore.
No, they were temporary posts. So now 692 posts have been created. Junior clerk posts have been now created. Would your lordship see page 1 of the compilation? Where is my compilation? Can't really here. Lordship may see page 1 of the compilation, my lords. Let me read it slowly.
Right.
page 1, 24/11/2006.
Yes.
I am directed to convey, my lordships have it, my lords?
Correct.
I am directed to convey the sanction of creation of 600 posts of data entry operator cum assistants who are to be engaged in different districts to render assistance for preparation and distribution of land passbooks. So the government in its wisdom thought that let us have a scheme where we will issue land passbooks for a period of 6 months at the rate of so and so each per the numbers indicated in the enclosed statement.
No. The point was that their engagement was temporary for 6 months.
Deeply obliged.
But this 600 posts that were created of data entry operator, what happened to those posts?
My lord, those posts also go away with this. These posts in the district, these posts were temporary posts.
No, where that it doesn't say posts are temporary.
Let me read it again. I am directed to convey the sanction of creation of 600 posts of data entry operator who are to be engaged in different districts to render assistance for preparation of distribution of land books. So their post was only meant for preparation.
No. That's right.
Yes. So this was not a permanent post or a cadre post. The submission to your lordship is this. Their job was that for 6 months.
No, but since they're continuing even today, they're obviously continuing against these posts.
My lord, they are continuing because by virtue of orders passed by your lordships.
That's since 2020. But I don't think these posts were abolished.
Yes.
I don't think these posts were abolished.
My lord, these posts were temporary posts. They were not permanent posts. I'll tell you lordships why. If they were permanent posts, my lord, let's test this argument. If they were temporary posts, there had to be a procedure for appointment. There had to be a cadre.
No, you've created posts, but you've not provided a procedure for appointment. That's the point.
My lord, I have created a post for a temporary period. I have created...
That is what is not clear. I don't know whether the post is for a temporary period because
my lord, it says...
In fact, they could not be continued even till today if it's a temporary post.
Yes. My lord, what
actually,
it says
I don't think there is something called creation of a temporary post.
My lord, if your lordships look at the service code.
All right.
Let us. Take the service code.
Rule 45.
If my lords take the service code, lords, kindly look at Rule 45.
Or 36.
Your lordship may see Rule 36 first.
Permanent post.
My lords have page Rule 36, my lord?
Correct.
These are permanent posts.
Right.
Permanent posts carrying definite rate of pay and sanctioned without time limit of time.
Right.
As opposed to, my lords, 45. Temporary posts means a post carrying a definite rate of pay and sanctioned for a limited time.
Correct.
So these were posts which were meant for a fixed term, they were meant for a fixed purpose, and they were meant with a fixed remuneration. As opposed to a permanent post, which is a cadre post. And 2019, my lords, if your lordship sees page 51 of the writ appeal, if your lordship sees page 51 of the writ appeal, my lords, kindly see page 51, para 2.5. What was the cause of action to come to your lordships? My lords have it, my lords?
Yes.
Page 51, para 2.5, just to tell your lordships why they came to this court. Your lordships have it, my lords?
Yeah, because no formal order of regular appointment has been made.
Yeah, let me see this. In the meantime, the GA department formulated so and so, but the same has no application case covered by so and so. But while granting extension to the contractual employees' appointments, the petitioner for a period of 6 years the opposite party with a letter dated 26/2019 made a stipulation or till completion of the posts for recruitment against 692 posts of junior, whichever is earlier. So they said, now we are creating 692 posts. So your post goes, you continue either till completion of the process of, you continue till the process of completion of 692. So what happens is that these 600 posts are continued till the 692 persons are appointed.
Or 6 months from 1st September, whichever is earlier.
Grateful. Grateful. So therefore, these temporary posts come to an end. And that is the cause of action why the petitioners approach this court. And your lordships held that single judge held, lords, that they are covered under 13(7), 17(9), 2013 because they have put in 6 years of service. And because posts have been abolished, posts have been created, they have gone through a recruitment process which corresponds to the regular posts. Nothing of that kind has happened.
All right. All right.
Grateful to your lordships. My lord, one more document. Your lordships, in course of when the matter was admitted, notice was issued, my lord. Your lordships wanted to see the order passed by the High Power Committee. And that your lordships will get, my lords, at page
25.
Page 25. I'm obliged. Deeply obliged. The Honorable High Court, while hearing writ appeal number so-and-so by order dated so-and-so, in the present case, High Power Committee was constituted to consider the claims of the respondent. Accordingly, as per para 1 of the GA Department resolution, High Power Committee consisting of so-and-so. As per para 4C of the aforesaid resolution, the committee must ensure that the concerned appointments fulfill the mandatory eligibility conditionalities elicited in para 1. Contractual appointments, engagements must have been made against contractual posts created with the concurrence of Finance Department on the abolition.
So they don't fulfill both these requirements, so they can't be regular.
And para 3, they say 1, 2, 3, 4, 5, 6. Grateful to.
My lord, my submission would be threefold, my lord.
Yes, please.
First, my lord, your lordship may see. I'll clarify, my lord, what the order that your lordship was passed, my lord, at the initial stage while issuing notice. I had appeared, my lord, through caveat, but no appeal, no petition was filed. Your lordship just wanted me to indicate whether you are going to file a contempt or not. I have said I will not file a contempt. Thereafter, they are continuing, my lord. Till that, they are continuing. And last continuation, my lord, is passed, my lord, on 2nd December 2022, saying that the writ appeal is pending and it will be taken up on 14/3. So you are allowed to continue. My lord, kindly see that order dated 18/11/2021.
Yes.
Your lordship's order.
Yes.
I'll just read this, my lord.
Yes.
Mr. Khuntial and additional government advocate for the appellant drew attention of this court to the so-and-so rules 2013 and submitted that among many grounds urged by the appellants to assail the impugned judgment of the learned single judge. One is that learned single judge was in error in observing that the above rules have no application in view of earlier resolution dated 17/9/2013 of the GA Department. According to him, the respondents would be considered in their turn for regularization terms of Rule 5 read with Rule 8 of the aforementioned rules, and that the decision of the state of Karnataka was Umadevi will have no application since contractual appointments of the data entry operators in the present case were not against sanctioned post of DO, but the sanctioned post of junior clerk, and that too on a short-term contractual basis. When asked by the court how many of the existing contractual employees have in fact benefited by Rule 8 of Rule 2013, AGS sought time for instruction, my lord. My lord, Rule 13 came in, my lord, in November 2013, 12 November 2013. Your lordship passed that order on 18/11/2021, asking them what you have taken so far this rule is concerned in respect of the existing contractual employees. The further submission took time. The further submission additional AGA is that the GAD resolution dated 17/9/2013 has to be read with the subsequent resolution dated 16/1/2014, which further clarify the conditions on which contractual appointed eligible for regulation. it is submitted that the High Court Committee has to examine whether the facts of the contractual employee satisfy the conditions of responsibility. When asked whether the present case HPC was constituted to consider claims of the respondent, again Mr. Khuntia stated that he has to take instruction. The learned Tribunal so an additional affidavit to be filed by the appellant within 2 weeks. They have not filed affidavit, but what my learned friend has said, referring to that page 25 minutes, what they have done, they have not filed the affidavit within 2 weeks. On the contrary, they held a High Court Committee meeting on 15/1/2022, as if the requirement of this honorable court was to see that you consider their case in terms of the High Power Committee. That was never the direction of this honorable court.
Anyway, nothing does.
No, I'll just indicate, madam. But that rule has no application to our case, madam. Why I am saying, madam, if you also look at, first, madam, kindly see that annexure 1, your lordship sees page 38 of flag Bible, our counter.
But there's a compilation now, you can even refer to that.
But that compilation he has now immediately submitted, my lord.
All right. Whichever you want. Page 38.
Yes, my lord. Page 38 of flag Bible. As I have understood, my lord, the sole contention of Advocate General was there was no sanction post and it was a temporary post created for 6 months. And though they have been continuing, but it was a temporary post. And there was creation of 600 posts of DEO. My lord, admittedly, my lord, he has also admitted there is no recruitment rule prescribed for the post of DEO.
Correct.
Then, my lord, kindly see, then some sort of, because the authority was given to respective collectors, my lord. So each collectors have made their own procedure, my lord.
Correct.
I have given a sample copy of Annexure 2, page 41, which my senior has also indicated. That some sort of selection was made by ADM.
Right.
It was referred to selection, the employment action, office notice for everything, my lord. And 150 candidates appeared, my lord, out of which, my lord, this 24 applicants were selected. Right. My lord, kindly see. Para 3, my lord, Annexure 3, page 42 of that Y. I'll just put, my lord, that Y only. Flag Y.
Yes.
This is the appointment letter of the petitioner.
Right.
Annexure 4 to 8, my lord, all the different appointments were made from out of the said selection process. Then, my lord, kindly come to Annexure 9, page 48. Your lordship said that the honorable single judge has indicated that Chief Secretary's minutes of meeting. My lord, kindly see page 48. And the relevant portion, my lord, the decision is page 49. I'll just read, my lord, that 49. This minutes of meeting taken by the Chief Secretary. I got it?
Yes.
On 28/4/2012 on regulation of contractual data entry operators against the Tahsils. At the outset, Principal Secretary, Revenue and DM Department stated 600 DO and assistant posts were created in 171 old Tahsils of the state by abolishing an equivalent number of consolidation grade 1 posts in 2006. It is not a fact, Mela, that there was no post abolition and creation. It was abolition, then creation. The post of DO was initially designated to facilitate issue of land passbook, but subsequently they attend all the computerization related work of Tahsil. Over the years, these DOs are found to be very useful to run today affairs of the Tahsil work. There are two categories of DO available in Tahsil office: directly recruited through test and outsourced from service providers. A regulation of this post is in public interest. RDC Cuttack stated that these posts are important and Tahsil work will suffer without this staff. Principal Secretary Finance Department stated that policy regarding regulation of DOs engaged in various departments is framed and sent to Law Department for concurrence. Once the policy is approved, the DO engaged.
Yeah. So this you can clarify this. When they say directly recruited through test.
Test, my lord.
No, there's no procedure for recruitment. I think the point being made, because you are relying heavily on this 17 September 2013.
Madam.
Even the single judge has accepted your plea that you are covered by that 17 September 2013 policy circular. Correct?
Yes, sir.
Now, if you turn to that 17 September 2013,
Well, that is page 51, my lord, of my...
whatever,
Well,
you can refer to whichever page. There are three conditionalities.
my lord.
One is abolition of posts, creation of posts, but abolition of some corresponding posts that you say it is mentioned in this note.
Yes, that letter is also given. That letter is also annexed.
Second is that the principle of reservation of posts has to be followed. We don't know whether that has been followed or not. But most important is following the recruitment procedure prescribed for the corresponding regular post.
There is
for instance, if you say the corresponding regular post is the consolidator grade 1 post, then we'll have to see what is the recruitment procedure for that consolidation grade 1 post and find out whether you went through that recruitment procedure. Only then this 17 September will apply. See, all three, there are three conditionalities. One is about creation of posts by abolition of some posts. Although it was argued that no posts were abolished when these posts were created, you are saying no, the consolidation 1 posts were abolished of 2006. The second is it should be by following a recruitment procedure. That's the second. The third is following the reservation under the ORV Act. But this recruitment procedure is, I think, something that you have to satisfy us that it was followed.
But only thing, my lord, that was my case before the honorable single judge, my lord, that whatever procedure that was followed by the respective collectors.
No, that can't be. There is no.
I cannot.
Yeah, you can't improve it.
I cannot improve. What was there in the?
I know. So then this 17 September will not apply.
No, I'll come to that. If you are, this is only Cuttack district. In respect of other districts, my lord, number of writ appeals have been filed. I have filed documents so that advertisement was made in each newspaper, official board. Then, my lord,
see, when they say recruitment procedure, see, the whole problem is this: that recruitment procedure will involve determination of vacancies, reserving some vacancies for, different categories. OBC, SCBC, or whatever you call it here, SCBC. SC, ST, you'll have to have reservations. Then there has to be a written exam followed by an interview.
Whatever.
I don't think in any of the districts, although different procedures may have been followed, this particular recruitment procedure was followed. I'm not sure.
No, if your lordship will say that because abolition was in respect of a particular category.
No, the word uses recruitment procedure for the corresponding regular post.
Well, there was no counter at which regular post, what procedure to follow.
No, I'm saying now that you're referring to this minutes of the meeting, now we know that they abolished the consolidation grade 1 post.
Absolutely correct.
So now you have to find out for regular consolidation grade 1 posts, what was the recruitment procedure? And whether that recruitment procedure was followed. I think your answer will be no. It is obvious that was not followed.
Well, I cannot develop what was there, madam. I cannot develop. Correct. Even if we will go to that rule, madam.
Correct.
I cannot satisfy that it was followed. Because the collector has to follow the rest. And you are the authority, you have indicated the collector, you have asked the collector to go for this. Even madam, the collector was asked to, though, in the event there is no...
So when they categorize, therefore, contractual employees, now we come back to this 2013 rules, which you say don't apply, but that 2013 rules, there is something to be said for the classification. Come to if you have this compilation, which the AG has handed over, that rule 4 of the 2013 rules,
page 8,
they classify into 2 categories. So you fall in the category 1.
I understand your lordship's view. The category which has been referred to in Rule 13 has got nothing to do with the regulation notification in terms of 17/9/2013.
I don't think he's arguing anything differently. He says if you fall in the 17 September 2013, you don't come under these rules. In fact, you both are arguing the same case. Only you're saying I fall under 17 September and he says you don't fall under 17 September. Correspondingly, you have to argue that you don't fall under the rules. And correspondingly, has to argue that you fall under the ruls.
But then has to be...
One excludes the other, sir. If you fall under the 17 September 2013, these 2013 rules don't apply.
Yes.
That even he doesn't dispute. His argument is, since you do not fall under the 17 September, circular, you have to necessarily be in category 1 of these 2031.
But that's 79/2013 and its applicability was taken note by the tribunal initially by a batch of cases relating to sales tax organization, commercial tax organization. There, initially they are recruited through outsourcing agency.
Outsourcing anyway goes out.
No, outsourcing agency, state outsourcing agency.
No. I'm saying this under 3 categories, only 1 category is saved for regularization.
Knocked
out. The outsourcing category is totally knocked out.
No, outsourcing category, now the Supreme Court has say in our favor. I'll come to that one. 29th, that is coming up.
Okay.
So far as this sales tax organization is concerned,
yes.
Initially, 137 employees were recruited.
Right.
Were given appointment on outsourcing basis.
Right.
After 3 years, they are taken to be direct contractual.
Right.
My lord, I've seen that notification, the minutes of meeting of the chief secretary.
Right.
There it was said 2 categories.
Yes.
One is directly through test, recruited through test, and the other is outsourcing agency.
Right.
So for both, my lord, the resolution was there.
Right.
Because it was said this resolution which will come up will be, my lord, for these categories.
Yes.
That is why, my lord, when thereafter, my lord, after 2008, they were taken to direct contractual in February 2008.
Right.
They approached the tribunal, my lord, saying that we have completed 6 years of service or regularized. On the basis of 17/9/2013, this was accepted, my lord, and the direction was you allow them regularization by issuing a formal order. Matter came before this honorable court. The division bench of this honorable court, my lord, said, accepted the judgment of the tribunal. Matter went to Supreme Court. That Jatin Kumar Das judgment, my lord. And Supreme Court, all those grounds, my lord, which was taken before the honorable single judge was negatived. And the honorable single judge has referred to that and what was the stand they have taken, my lord, before the Supreme Court. They have never said before the honorable single judge, their case was, my lord, that they are not coming within the 3 categories which has been enumerated in 17/9/2013. Only this was the ground. They have never taken that rule 2013 has application and the honorable single judge has forgotten to refer to that. It's not the case. The only grievance, my lord, if you also look at their counter.
No, but let's stick to the 17th September itself.
Well,
so 17th September, how do you satisfy that second requirement of recruitment through a regular procedure?
Well, my simple, whatever is that, well, I can say only test. Well.
No.
It was only a test conducted by.
In that other case, that sales tax case that you're referring to.
Well.
Sales tax organization.
Same, my lord, same test.
No, let's see the judgment.
Well, I'll bring that. That judgment is there, my lord. First, my lord, I'll place, my lord, the judgment of the. And based on that, my lord, number of judgments have been delivered by your lordships, dismissing the state's appeal. And my lord, the last judgment was 10/3/2023. I have shown to your lordship in the last occasion. Same 17/9/2013. And they have implemented, my lord. All the implementation orders I have also enclosed, my lord, along with my counter. Each and everything, my lord, I have submitted. My lord, kindly come to that. Go to. Well, kindly come to page 61, page 61, 64 of flag Y. मतलब पेज that is running page, mirror. Page 61, my lord, of the writ appeal. Para 5, my lord, is my contention. Para 3 and then para 4, my lord, I have referred to all the judgments, including Jatin Kumar Das, last of the at that time, my lord, Vishwamitra Parida, which was also your lordship followed that. Then para 4, my lord, is in the submission of Mr. H.M. Dhal and additional government advocate argue with vehemence, contending that the petitioners who are working data entry operators have filed a petition with a prayer to issue nature of mandamus to regularize their services. One of the preconditions for exercising power under Article 226 of the Constitution for issuance of writ of mandamus is that the court must come to a conclusion that the aggrieved person has a legal right which entitles him to any of the reliefs, and that such rights has been infringed. It further contended that claim of the petition for regularization of service in accordance with the GA Department.
Sorry, which paragraph are you reading?
That is, my lord, page 61 of the writ appeal. They stand with the government, my lord, before the honorable single judge.
Right, Vishwamitra Parida. Yes.
My lord. I'll read, my lord, from page 61. My lord.
Right.
For contrary, H.M. Dhal and counsel, government advocate argued that with vehemence contending that the petitioners were working as that time the operators have filed this petition with a prayer to issue a writ of mandamus to regularize their services. One of the preconditions for exercising power under Article 226 of the Constitution of India for issuance of writ of mandamus is that the court must come to the conclusion that the aggrieved person has a legal right which entitles him to any of the reliefs, and that such rights has been infringed. This is further contended the claim of the petitioner for regularization of their services in accordance with the GA Department resolution dated 17/9/2013 on completion of 6 years of service is not automatic, and such resolution has been clarified by subsequent resolution dated 16/1/2014, which provides that no contractual appointee shall be eligible for regular appointment unless
para 6 onwards is what the division bench should be doing.
Well,
all right.
And my lord, whatever ground, my lord, they have taken has been taken note of by the honorable single judge. And if your lordship look at, my lord, have para 8, page 67.
All right. Now, all this is, see, this is general observations on what the state should be doing and not exploiting labor and all that. We're not in that kind of a situation here.
But here, my lord, kindly come to page 83, para 22.
That's the most crucial thing, sir. That's the most crucial thing.
And there, the honorable single judge
proceeds on certain basis, correct?
My lord. And so, Jatin Das case is concerned, it is squarely applicable to my case because similar nature of appointment.
You're not showing Jatin Das, sir. I'm asking you to show, you're not showing it.
Well,
where is that Jatin Das?
Jatin Das judgment, my lord. It is, my lord.
See, the presumption in page 90, just to complete your reading of the single judge's order.
Madam. My lord is referring to
page 90, running page 90, para 25 bottom. But the petitioners in the instant case.
But the petitioners in that case have been appointed through a process of selection.
Is that right? See, this is not the point. This is where the difficulty lies, sir. You're not appointed through a process of selection. The single judge proceeds on the basis that you are appointed through a process of selection.
Well, if your lordship look at, your lordship is correct. If your lordship look at that 24/11/1986 letter, there, my lord, collect was given to have a test. They have never indicated.
Test is one thing, sir. That's what I'm saying. This is the word test is a very loose, very broadly you can say test. Some people have walk-in interviews. Some people have simply some written test. Some people conduct only a test plus interview. There are various ways. Each one can adopt a different thing. But the 79/2013 circular says recruitment procedure applicable to the regular post. So once that 79/2013 is very particular, that there must be a recruitment procedure followed.
This was taken note of. What was the regular test? That was also considered by the tribunal initially, my lord, when they have taken, my lord, that page 203 of para Y, flag Y.
All right, 203 is it?
Yes, sir.
1 minute. Flag Y.
Well, kindly come to.
No, 1 minute. Where is this flag Y? Must be here.
Hello.
203.
My lord, 203.
1 minute. This is OAT.
Yes, sir. This is the OAT judgment dated 17/5/2017.
All right.
The judgment starts from 207,
Right.
206, my lord.
Right.
There, my lord, the claim was for declaration for a direction to regularize in terms of 17/9/2013.
All right.
And we have referred to, my lord, in that way, my lord, all the similar cases where regulation has been made. And my lord, kindly come to page 2 and 5. What your lordship is just wanting.
Right.
The 3 mandatory conditions.
Right.
2 and 5. And this judgment has been upheld by this court and by the Honorable Supreme Court.
Right. So there are clause 2 is what I'm asking about. Contractual appointment engagement must have made following the
I'll just see, but 3 conditions they have indicated. Then matter how they have dealt with. So far as first eligibility condition is concerned, it is undisputed that the appointment engagement of the present applicants have been made against contractual posts created with the concurrence of the finance department. So by the second eligibility condition is concerned, we are of the opinion that in absence of any recruitment rules guiding the principles of recruitment to the post of DEO and junior programmer, the procedure adopted by the duly constituted selection body was correct, and they had conducted a fair selection and appointed these applicants who are continuing since 2005. And the performance report shows
that the problem rises, sir. See, the problem is we are of the opinion that in the absence of any recruitment rules.
Yes.
So the problem is if there are no recruitment rules, you can't have a regular recruitment procedure according to the tribunal.
Yes.
But what you are contending is, in fact, there was an abolition of posts.
Yes.
And correspondingly, these posts were created.
Madam.
The 79/2013, if you look back, if you read that line very carefully, following the recruitment procedure prescribed for the corresponding regular posts. So the corresponding regular posts that were abolished to create these posts, the recruitment procedure for that post has to be followed.
But that was not the conditional merit in that abolition letter.
No. We are on 79/2013, sir. We are discussing the conditionalities of 79/2013.
Madam. The tribunal held some sort of selection procedure.
Will that be enough? Because the
Supreme Court has time and again said some sort of selection procedure must be there.
No. We are not on. Supreme Court probably did not interpret. Did Supreme Court interpret this resolution?
No, this has been the third conditionality is ORB Act.
That's all right.
ORB Act is not applicable in terms of the section 3D. This was taken note of by this honorable court in the division bench. That is page 220.
1 minute. No, but there's no. It's not a reasoned order.
No, para
4.
Para 3, can you see para 3? Para 3, Para 3, all the 3 conditions have not been fulfilled. That was the stand of the government. Then, para 4.
It simply says we are in agreement. There's no discussion.
And Then that is correct. I don't dispute that. Whatever there, I cannot say, I cannot write something which was not there. Then kindly see the Supreme Court order.
All right.
225.
This is same Kuni Ahmed, sir.
No ground for interference, and they have taken the plea. And the plea they have taken before the Supreme Court.
This is covered.
You also just allow it. The ground they have taken before the Supreme Court. What was there before the tribunal, before the dishonorable court?
So the one basic distinguishing feature is this is DEOs and sales tax. This is the DEOs and sales tax.
Yes.
So we are now.
DEO post was never there, my lord, in any of the.
But you yourself said, see the way of truncated reading. If you come back to 17/9/2013, let's deal with the 17/9/2013, sir.
Well,
I think let's frontally deal with that. It must be made against contractual posts created with the concurrence of the finance department on abolition of the corresponding regular posts. So tribunal in the Jatin Das said there was no corresponding post which was abolished. And therefore, these are standalone created posts. Since there is no recruitment procedure for this, some sort of recruitment procedure is good enough. So, and because of 3D of that act, reservation doesn't apply. Whereas what you are arguing is, it was created on abolishing the posts of consolidation 1, grade 1.
Yes.
Once you say this is done by abolishing certain posts, that these posts were created, then the next rule is following the recruitment procedure prescribed for the corresponding regular posts. That's the second rule. So that conditionality was not noticed in Jatin Das because the Jatin Das case proceeded on the basis that since there is no corresponding post that has been abolished, there is no recruitment procedure for such post.
Admittedly, as on date, DO post has no recruitment rule has been prescribed till date.
No. This is the recruitment procedure for the corresponding post, sir. Just read carefully, no?
Corresponding regular post.
What do you mean? What do you understand by this expression corresponding regular post?
Corresponding regular post means, according to me, if the corresponding regular post of DO is there,
No. Where's the question? If there is a corresponding regular post of DO, why would they abolish it, sir?
No, equivalent post, equivalent post.
No.
Corresponding equivalent post.
Abolishing. I'm saying if there's already a post of DO, there's no question of abolishing. They're creating a post by abolishing some posts, sir. Which is that post they have abolished? You yourself read.
Yes, that is my lord, consolidation grade 1.
But so once you yourself say they created these 600 posts by abolishing consolidation grade 1, the second conditionality is you should follow the recruitment procedure prescribed for the corresponding regular post.
That is why, my lord, if you also look at for a minute, page 49. That flag Y. I'll again read, my lord, that one.
Which one?
That flag Y, my lord, page 49. What was in the mind of the government, my lord, when they have taken the decision? Before bringing that regulation notification. If you also look at page 49. And the Honorable Single my lord called for the records of the department to find out what was the reason and what was the modality for the post of DO. Page 49, my lord.
Correct. So this much is clear. It is by abolishing equivalent number of posts.
Equivalent number of posts, my lord.
Correct.
Not corresponding posts. My lord, kindly see, when your lordship is harping on a particular word, so it must be there, my lord, in that decision. And my lord, who are the participants, my lord, kindly see, next page.
Yes.
Can you see next page? Principal Secretary, Revenue DM Department.
So these were regular posts, sir. This consolidation grade 1 post is a regular post.
Yes.
That has been abolished.
That has been abolished.
So that is the corresponding regular post. You abolish consolidation 1 and create DO. Correct? So this, when you look at the word corresponding regular post, this corresponding regular post is that of the consolidation grade 1 post. That is how it is, sir. Otherwise, this first conditionality is also not fulfilled then. You're in trouble. See, the problem is, in order that 17/9/2013 must be fulfilled, all three conditionalities have to be fulfilled.
And my lord, kindly see, my lord. I cannot, my lord, what was the test they have conducted, my lord? They have gone for a sponsoring names from the employment exchange.
All that is fine. Because you relied on 17 September 2013, we have to examine carefully and see whether you satisfy the requirements of 17 September 2013.
Well, if your lordship will take that, my lord, in respect of 2013.
Yes.
2013 has no application, my lord. Kindly see.
No. We'll now go to the rules. We are on your case, sir.
Well,
your cases, those rules don't apply.
Yes.
So let's keep it aside. Your case is that 17 September 2013 applies. So we'll test that. So let's not go somewhere else. If you have to test 17 September, 3 conditionalities have to be fulfilled.
Your lordship's interpretation, I cannot vouch that it is not correct. It is one way of looking at it, my lord. If your lordship look at page 49,
which is the other way. You can't say that Jatin Das is the other way, because Jatin Das doesn't seem to have even noticed the need for abolishing a post, for creating a post.
No, it was in Tahsil case, my lord. It was in Tahsil case. It was in Tahsil case, my lord. This 49, page 49 was not a part of that, my lord. In respect of Tahsil office, my lord, a specific decision was taken. That's why, my lord, we have annexed this. But in respect of commercial tax organization, my lord, it was through outsourcing initially. Two direct recruiters.
So if you're not going to Jatin Das, let's keep Jatin Das out. You're saying
no, Jatin Das, my lord, I'm applying Jatin Das, my lord, because of this, my lord. That some sort of test is followed.
1 minute. So the crux of this whole case is this circular 17 September 2013, correct? That's the crux. If you succeed, if you fulfill this, if you don't fulfill this, you don't succeed.
Well, I leave it to yourself. By that, my lord, I have been continuing my series. My lord, that is why, my lord, this honorable court asked me, my lord, to furnish each and every extension orders. That is Annexure 21 series, my lord, kindly have a glance.
See, the argument there is simple. They say if you do not fall within 17 September 2013, you fall in category 1 of that 2013 rules, which is in a sense not contrary to your argument. You're saying, since I do fall in 17 September, those rules do not apply to me. This is your argument. So it's the same argument. It's the same argument, sir. So the question is, they say if you do not fall in 17 September 2013, you can take advantage of the 2013 rules. You'll get your relaxation. You join the queue. You become part of that rule then.
My lord, that is not available, my lord, because they have repealed that 2013. And regularly, all of them, my lord, those who have been appointed in 2013, immediately upon completion of 6 years of service, that notification I have got, my lord, can you see?
Which one?
That 2013.
Those 2013 rules have gone.
Yes. And my lord, if your lordship look at the...
I think it's here also. Page 4 and 5.
No, that rule, my lord, new rule, my lord, they have...
Yeah, 16/10/2022. They've abolished.
What we are saying is the benefit of Rule 8 can be extended by your lordships, just as in the Delhi case. The benefit of weightage.
Delhi case, my lord, it was a different. There was no scheme.
If those rules have gone altogether, then what happens?
My lord, the benefit in 226, my lord, your lordships can always give them the benefit of, my lord, like in the Delhi case, where the Supreme Court said that they have to be given some leeway. My lord, may I show that judgment to your lordships? Kindly turn to...
My lord, Delhi judgment, my lord, there was no scheme. First of all, there was no scheme. And they were having, my lord, 3 to 4 years of service. If you also look at that Delhi judgment.
What is this memorandum? You've just now given this.
Yes, my lord. That notification I have enclosed, my lord. I have enclosed two enclosures, my lord. One is right now there are...
Can you examine this and get back to us? Because he's just handed it over.
Your lordship pleases.
Just give it to him. Let him examine it.
Lordship pleases.
Yes, my lord. Only one aspect, my lord.
No, we'll continue, sir. Let him examine it and get back to us on this.
There are
two aspects. Mr. Parija, there are two aspects.
My lord.
One is, since the 2013 rules are not there anymore, they've been repealed.
Correct, my lord.
Where does it leave these people? That is question number 1.
Yes, my lord.
And question number 2 is, he says there are so many vacancies available.
7,500 vacancies.
75?
100 vacancies. 75,000 vacancies well, available. That will available up to 31st of December.
So maybe you'll just want to take
I'll respond to
instructions. All right. All right.
And my lord, they have completed more than 16 years of service. My lord, kindly give. And today, my lord, item number 58, your lordship delivered the judgment in court also. Item number 58.
No, that was something else. That again.
No, that was my lord, same, my lord.
Everything is not the same. So anyway, everything is not the same. All right. That is that consumer.
Yes, yes, more than 20 years of service. And my lord, here, my lord, 79/2013, following Jatin Das, your lordship is given judgments.
Anyway,
I've given the number of division bench judgments.
But some matters relates to that outsourcing regulation. That is in the list. In the
outsourcing will be on 29.
Yeah, 29. Milord, in the special list that is listed, I have provided the numbers.
Some cases are listed today.
So Lordship may call this matter on 29. I have provided the number.
27.
Yes. The sum of the matter has been wrongly.
This list wrongly. You de-link and give it on 20. This will take on 28th. 27th is another huge batch.
29th is the holiday. Oh, sorry. This is March. I was looking at the other. 28th.
Yeah, 28th March. We continue on 28th March.
Pardon to make a mention, my lord. There is a writ appeal tag today in the specialist, my lord. Writ appeal number 402 of 2022, my lord. On the last occasion, your lordship have directed the state to take instruction whether they are covered by the honorable order passed by your lordships or not. Because it's a case except for
call that matter tomorrow so that I can.
All right, that will also be on 28th. All right, 28th.
My lord, first subitem writ appeal number 61 by 2022. In this case, I am appearing on behalf of the respondents. This is not similar matter. A single day disposal, your lordship may remand writ appeal number 61 by 2022.
Who's there and who's from the other side?
State, my lord.
All right.
Lot so
61 by 22. Let's see what it is about. Where is it impugned order? Which page? No, but it does say Patita Pavan Das.
Page 14.
It's the same. It's following Patita Pavan Das.
The present petition is not continuous DO. He is underwater as
He's not a DO.
No, he is not a DO, my lord.
Oh,
a little different matter.
See, he's himself conceding that. You say the impugned order.
But that has been referred to that.
I know, was passed on the very first day by the learned single judge following the judgment delivered by the single judge in writ petition civil 19951 of 2020 bracket Patita Pavan Datta Dash versus State of Orissa on 9 September 21 paragraph. Today, counsel for the respondent himself states that his case is not covered by the aforementioned judgment as the facts in his case are different. Full stop. In any event, no opportunity was provided to the appellant state to file a reply to the writ petition. On the above ground, the impugned order is set aside and writ petition civil 10287 of 2020 is restored to the file of the single judge in the roster bench, where it will be listed for hearing on 12th July, counter to be filed by 28th June, rejoinder by 12th July. No further time will be granted. The single judge will proceed on merits and dispose it of as expeditious as possible. The writ appeal is disposed.
My lords, pardon to mention, my lords, there are certain drivers of city GST department. They need to be detagged from the list, from the special list. 5 of them, my lords.
Those matters are first day disposal.
First day disposal. If you want, it can go back. If they are first day disposal, then they can go back.
No, my lord, so I wanted to be heard, my lord. So can it come on 28? But my lords, my detag it since it's driver's matter and admittedly that at sanction post. My lords, I'll satisfy to that effect. My lords, my detag it. No, that's my limited prayer, my lords.
DTAG meaning anyway it has first day. So there's no counter, no rejoinder, nothing.
As lordship pleases, sir.
All right. So those 5 matters, list them for the single judge on 13th July. Follow the same. So those 5 numbers you give. Similar order. They are there in the special list, right?
Yes, sir.
You put down his name for the respondent. All right. All right. I'll just come back.
Pardon, my lord. My lord, my matter is 171, your lordship. Now I'm feeling.
Let's see, sir.
My lord, matter may be adjourned because I'm feeling the chest pain, your lordship. 71. Next week, my lord, any day.
Who's for the other side?
My lord, to convenience any day, my lord. Today I'm feeling uneasy now. Since last one hour.
No, what's the matter about?
Matter cognizance of Cognizance order, your lordship, casting of cognizance order.
Under what provision? 498A. You raise all the pleas, sir.
My lord.
Permit you to raise.
This is a very sensible case, your lordship. There is going to be compromise, and the informant is going to highly affidavit also. He has also stated that.
Who's for the other side?
Other side.
Who's for the other side?
Item number
Sonia Malik.
71. 71.
Yes, your lordship.
Yes, it's with me.
The informant lady also ready to file a compromise application. Your lordship.
Counsel, the petitioner maintains that the respondent number 2 is ready to file a compromise petition.
My lord, my lord.
However, counsel, there's no counsel. Although Mr. Sunil Kumar Parida, advocate, entered appearance for respondent number 2, opposite party number 2. Today, none is appearing. You say interim order to continue this before the roster bench on 11th May.
Obligation.
Supplementary list, fresh admission item number 1, CRLMC 2564 of 2016.
May I please, Lord, sir. I hear, my lord, the petitioner challenges the impugned order on the Annex 8, my lord. That is order dated, my lord. Agents of offense under section 138 of Negotiable Instrument Act, my lord.
Right. Permit you to raise all pleas, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petitioner is dismissed.
Item number 2.
Is vacated. Right. None appears dismissed.
Item number 3.
None appears dismissed.
Item number 4.
Same order.
Item number 5.
Same order.
Item number 6.
Same order.
Item 7.
Item 7, my lord, no instruction. No instructions dismissed.
Item number 8.
None appears dismissed.
Item number 9.
None appears dismissed.
Item number 10.
10, your lordship, I'm challenging the order of taking cognizance that is available to your lordship, the Annex 2, page 13. Cognizance was taken under section 306 by 34, your lordship.
Correct.
My lord, the case is like this, your lordship. There is a love affair between the deceased and petitioner number 1. Both were in love.
Abatement to suicide, sir. Basically.
Absolutely no case, your lordship. Absolutely no case. Because the girl's parents went to the deceased house. They saw the house, broke up the marriage.
Right.
All that reasons he committed suicide, my lord.
And this is not even compoundable, sir. Permitting the petitioner
no,
to raise.
My lord, there is no reason to take cognizance 306, your lordship.
Let it proceed. See, permitting the petitioner to raise.
Lordship, I have a judgment of the Honorable Supreme Court, your lordship. Absolutely no. Lordship, may I ask the state government what is the ingredients of 306? How cognizance was taken on the 306, your lordship?
Yes. Permitting the petitioners to raise all pleas at the appropriate stage. The petition is disposed of. All right.
Item number 11.
Item 11, I only pray let the trial be expedited, my lord.
It will be open. You say permitting the petitioner to raise all pleas. The petition is disposed of. It will be open to the petitioner to request the trial court to expedite the proceedings. All right.
Obliged.
Item number 12.
Let 12 in this matter, lodged on year 1998. Since 25 years have passed, accused have not been, all the accused have not been offended, so trial has not been proceeding.
So anyway, nothing, no harm, sir. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item 13.
13, my lord, petitioner may be permitted to take all those grounds at the time of framing charge.
Right. Permitting the petitioner. Right.
Item 14.
14, my lord, no instruction. My lord.
No instructions dismissed.
Item number 15.
None appears dismissed.
Item number 16.
Same order.
Item 17.
Same order.
Item number 18.
None appears dismissed.
Item number 19.
None appears dismissed.
Item 20.
My lord, no instruction, my lord. Pursuant to Annex 3, that the matter has been compromised by in the court below.
All right. No instructions dismissed. Fine.
Item 21.
None appears dismissed.
Item number 22.
Same order.
Item number 23.
Same order.
Item 24.
Same order.
25.
Same order.
Item 26.
And I filed a memo, my lord, for
Memo taken on record.
infectious.
Infractions dismissed.
Item number 27.
None appears dismissed.
Item number 28.
Same order.
29.
Same order.
Item number 30.
Same order.
31.
Same order.
Item 32.
Same order.
33.
Same order.
Item 34.
Same order.
Item number 35.
39, my lord, I have filed a petition under section 482 CRPC to quashing for the entire proceeding under section 12(1) of the Protection of the Women from the Domestic Violence Act. Before the Lawrence JMFC, Bhubaneswar, which is a highly illegally and is injustice under the act. Quashing the proceeding under section 482.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Item number 36.
None appears dismissed.
37.
Item number 37 and 40, Your Lordship. We have sent the notice to the client of ours, Your Lordship.
It's all right. It's all right. Say permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
Item 38.
Obliged, Your Lordship.
So item 38 means no instruction notes.
No instructions dismissed.
39.
None appears dismissed.
40 taken. Item 41.
May I please, Your Lordship? Your Lordship, I just need some time. There are defects that I have to file a certified copy of the order that has been passed by the learned trial court. I need some time, my lords. It has been listed
What's
after.
a prayer? No, what's a prayer?
My lords, to quash the proceedings, to stay the proceeding that has been, what has happened, this is a 498 and a DV case, where DV case, section 14 of DV case prescribes for a counseling, which without a counseling, the order has been passed. That is, Your Lordship may kindly give us some time so that we can file the certified copy of the order that was
Not
filed.
necessary, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. Yes.
Item 42.
May I please, Your Lordship? May kindly permitted to withdraw, sir.
All right. Dismiss this.
Item number 43.
None appears dismissed.
Item 44.
None appears dismissed.
Item number 45.
Same order.
Item 46.
May I please, Your Lordship? My Lord, I questioning inclusion of 307 only, my Lord. If Your Lordship will, it happened like this, my Your Lordship. We lost an FIR against the opposite party number 225. That was registered as Rajkanika PS case number 98 dated 7/6/2013. In order to counterblast this, they lost the FIR on the next day, which is 99, my Lord. Now, if Your Lordship will look at page 20, the injury report, all the injuries 20 and 22 are simple in nature. In spite of this, now charge sheet is under also 307. I am questioning only inclusion of 307 in this, Your Lordship.
That you can point out to the trial court.
Yes. If Your Lordship will look at, Your Lordship may be satisfied, my Lord.
Okay. Where?
Page 20.
20.
20, my Lord.
All right.
The injury report. Should I give a copy? Your Lordship?
No, it's all right.
It's there. All are simple as Your Lordship finds.
There are two lacerated injuries. Where are those lacerated injuries? Left arm and
arm, shoulder joint, left knee, and if Your Lordship will look at
shoulder. But this is only the charge sheet that included 307, right? Charges have not been framed yet. That you can point out at the time of framing charge.
Charge sheet, Your Lordship, Your Lordship, this is stall since not today, my Lord. It has started. Possibly they have given it in the charge sheet also. I am holding the charge sheet.
No. Charges have been framed or not? Because as an interim order, maybe charges have not been framed. So you can point out at the stage of framing charges.
Should I take instruction?
No. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court.
I came to Your Lordship after the notice charge were framed, my Lord. Why I am saying after the bail only,
No. You have come at the stage of charge sheet, sir. The interim order is vacated. All right.
Item 47.
None appears. Interim order is vacated.
Item 48.
Same order.
Item 49.
Please, my lord.
Same order. Oh, you're there. Yes, please.
My lord, this is an order, quashing of order of cognizance at annexure 3. The only
Yes.
point is that 498A and 294 is not met out because I am not nowhere related to the victim. The ingredients of 498A is not at all applicable to me.
What are you? Who are you?
I'm a teacher. I'm a neighbor. I'm a teacher and a neighbor to the victim as well as to the husband. That is the accused number 1, the other accused, against whom the charge sheet was submitted. The ingredients of 498A is not at all attracted to me. Even for 294 also, my lord. My lord, may kindly have a glance to the FIR copy. Nothing has been spelled against me. Except the fact.
No, you see, service on opposite party number 2 who was added has not completed. So no service has been effected for 5 years now. What has happened in the last 5 years, sir?
My lord, lastly, the case got listed in the month of December 2019. After that, I have after reopening of the court, I have filed.
No. See, in the trial, because it only says as an interim measure, no coercive action shall be taken against the petitioner. What has happened in the trial court?
Charge has not been yet framed here.
How? Why? See, only you had come here. Charge should have been framed against everybody. And only no coercive action. No coercive action only means that you will not be arrested or something.
The thing is, the case, while the case was pending before the.
You can raise this plea, sir. You can raise this plea at the stage of framing charges. All right. Permitting the petitioner to raise all pleas at the stage, appropriate stage, the petition is disposed of, the interim order is vacated. All right.
Obliged.
Item number 50.
My pleasure, Lordship. Petition challenge the order of cognizance under section 138 to my law only ground that notice was not issued within the stipulated period of 30 days under section 138 clause B, my lord. In this ground, I have cited the judgment of this Odisha High Court, my lord. And the notice was issued after 61 days of the dishonor of the check, my lord.
That now I think Supreme Court is very clear. This is a mandatory requirement, sir. The court on perusing the impugned order is unable to find any error having been committed by the SDGM. Impugned order dated 15 September 2016. Or we'll just say permitting the petitioner to raise all pleas at the appropriate stage. In the trial court, the petition is disposed. Right. Interim order is vacated.
51.
51. There was a dispute between the husband and wife. I'm for the husband, my brother is for the wife. My lord will file a joint affidavit. Your lordship may call it some other day. Will file a joint affidavit. It can be quashed.
All right. Counsel petitioner states that the husband and wife will file a joint affidavit, having settled the disputes. List before the roster bench. On 4th May, interim order to continue.
Item number 52.
May I please, your lordship? Lord, petitioner challenges. Annexure 3, page 17, my lord. The order of cognizance, my lord. Here is the offense, my lord. 47 Bihar and Orissa Exchange Act, my lord. The involvement of the petitioner, how lordship may kindly page 16. How the petitioner is the owner of a liquor shop, my lord. One person arrested. Some liquor has been seized from their possession. He admitted that he has purchased the liquor from the petitioner, my lord. He is the owner of a liquor shop, my lord. How?
It's all right.
Except the statement of the court, nothing has been.
Yeah, it's all right. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. Interim order is vacated. All right.
Item 53.
The petitioner challenged the order dated 26/4/2017. Lordship, here the Lawrence JMFC has issued NBW without following the procedure of law. Lordship.
It's all right. You appear on a particular day, sir. Yes. You say the petitioner will appear before the JMFC. Jaleshwar on 26th April, and thereafter seek appropriate orders in that court. No further directions are called for. The petition is disposed.
Item number 54.
Please, your lordship. My lord, here the petitioner is challenging the order of cognizance, my lord. My lord, the order of cognizance dated 28/11/2016, which was passed by the Learned JMFC Patamundi, my lord.
498A, sir.
498A, my lord.
304B.
Here the petitioner is a
304B.
well, petitioner is the mother-in-law, but as per the going through the 161 statement, at the time of occurrence, the
point is all at the time of framing charge.
petitioner was not staying with the.
That's right. You pointed out at the time of framing charge. Right. You say, permitting the petitioner to raise all pleas at the appropriate stage. Petitioner is dismissed. The interim order is completed. Right.
Item 55.
Well, it has become infectious as the petition has been acquitted.
Memo taken on record, disposed of as instructions. All right.
Item number 56.
None appears dismissed.
57.
Millers, I appear on virtual mode, Millers.
Yes.
Here I have challenged the order of cognizance under section 406 and 420 by filing a forged receipt and page 16, Millers.
Yes.
This type of receipt is never given by us. The receipt we have given, I have filed also a sample and page 14. Cognizance has been taken.
It's all right, sir. You can point this out at the stage of charge, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is completed. All right.
58.
None appears.
Item number 59.
Same order.
60.
Changing the order dated 10/3/2017 under the cognizance order annex 4. The allegation against the petitioner is that the deceased has died due to the accidental of
These are not
gas leak.
matters for quashing, sir. This you'll have to point out to the court. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Item 61.
None appears dismissed.
I am for the opposite party.
None appears to the petitioner dismissed. He's for the opposite party. All right.
Item number 62.
None appears dismissed.
Item number 63.
Same order. The interim order is vacated.
Item number 64.
Millers, the earlier counsel, Mr. Pradhan, had expired during Corona period. Millers, I am filing my fresh wakalatnama. I needed to reconstitute the file, Millers. Kindly give some time, Millers.
No, what is it about? Tell us.
I have just sought instruction from client. It is under section 307, Millers.
Take these pleas at the appropriate stage.
Millers, may kindly given one opportunity so that I can place before what is the matter. I am not aware of the matter.
See,
yet,
you've
Millers.
all got stay for 5 years and 6 years. Nothing is happening because of that.
Millers, during Corona period, Mr. Pradhan has died.
No, that's all right. You say his wakalat is taken on record, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Interim order is vacated. Right.
Item 65.
On behalf of Mr. Rai, kindly be taken up for one capture, my lord.
For what, sir?
Mr. Rai is affected in the kidney affected, my lord.
It's all right, sir. Same order is going to be passed, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated. All right.
Item 66.
Limited prayer of the petitioner lordship, the annexer to counter each other. The prayer is that both boards should be tagged because the witness same, all the matters also same lordship, date of occurrence same lordship. I filed the petition and annexer 4, page 22. It was not intended by the lordship. It says that
no. Only one suit was one matter was stayed, which is GR case 541.
Lordship.
What happened to the other case?
Otherwise, both are state, lordship.
No, only one is state, sir.
Lordship, both are because
only one. GR case 540 alone is state.
Lordship.
What happened to the other case?
Other lordship, the instruction was sought for, which is available flag D also. I think noting is there. Last occasion sought for the instruction that was available flag B something, lordship. Last occasion instruction was called for.
Already consigned, sir.
Yes.
Complaint petition rejected. So that's over. The report is that ICC number 192 of 2017 has already been consigned to the district record room as the complaint petition was rejected. In that view of the matter, the present petition has become infructuous and is disposed of. All right.
Item number 67.
My lord, I am pleased, Lordship, my lord. And order of cognizance is under challenge, my lord. Order dated 12/5/2017, my lord. Initially, FIR has been registered under section 498 and other offences. Petitioner is the married sister-in-law, my lord. Police submitted a final report against the present petitioner. Subsequently, the informant filed a protest petition. In protest petition, Lord, and casted to cognizance.
Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. The interim order is vacated.
My lord, obligement.
Item 68.
None appears dismissed.
May I please your lordship? Lordship, FIR out of a complaint case. Meanwhile, the complainant and the petitioners, the matter has been amicably settled between them. And it is the ancestral land of the opposite party number 2 is being purchased by the petitioners.
It's all right, sir. You pointed out to the trial court, permitting the petitioner to point out, to urge all the pleas at the appropriate stage in the trial court. The petition is disposed.
Item number 69.
May I please your lordship? My lord, in this case, the petitioner has challenged the order of cognizance and the Lord Magistrate took cognizance under section 420, 468, public 34 of the Indian Penal Code, read with section 103, 104 of the Trademark Act, my lord. My lord, Trademark Act section 115 mandates that the investigation is to be carried out by officer of the more than the deputy superintendent of police.
You can point out all this.
My lord, in
there's
this
also other provisions. There's 420, 406.
The case has been
Anyway, it has to go on.
SIA police, my lord.
All right.
So
that you can point out, permitting the petitioner to urge all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated. Yes.
Item number 70.
None appears dismissed.
71 will take. Item number 72. May I please, Lordship, my lord? The petition is challenging the order taking cognizance, my lord. There is annexure 2, my lord. Offence order 498A 3023 of IPC, my lord. But what has happened, my lord? The informant is the opposite one or 2. They lodge 2 cases. First, informant lodge a 1cc case before the Lord SDGM Udula in the same offence, same person, and taking cognizance. Then, after 1 year, lodge another FIR against the same person, the same offence, my lord. But the Lord SDGM Nilagiri also took cognizance, my lord.
Sorry. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. The interim order is vacated.
Well, one case may be stayed.
All right.
Item 73. Well, in Article 20, clause 2, clearly said that.
That the court knows, sir. You could point out to the court there. Yes.
Item number 73.
73. 73, my lord, I filed a petition under section 482 of CRPC to quash the cognizance order dated 9th August 2017, passed by the Lawrence Additional Sessions Judge Raurkela of Special GR case number 6 of 2017.
SCST also. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. The interim order is vacated. Right.
Item 74.
My lord.
Item 74, my lord, matter may be disposed of, permitting us to raise all the points.
Yeah, permitting the petitioner to raise all pleas at the appropriate stage.
Nice.
Right.
Item 75.
None appears dismissed.
Item number 76.
76, my lord. Here petitioner is preferring this application for quashing of entire criminal proceeding on that, my lord, here that at the time of occurrence, on the ground that at the time of occurrence, the present petitioner was arraigned as an accused person in another case and he was inside the judicial custody, which
all
reflects...
alibi plea and all you have to prove, sir.
Yes, my lord. Yes, my lord. I have given that annexure 4. My lord, kindly have a glance to the annexure.
That you point out to the judge there, sir. At the time of framing charges, you can point out.
My lord.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated. Right.
Item number 77.
My lord, item number 77, no instruction, my lord.
No instructions dismissed. Interim order vacated.
78.
None appears dismissed.
Item 79.
Same order.
Item number 80.
There has been compromise between the parties. I have paid all these things, but
counsel for the opposite party number 2 agrees that the disputes between the parties have been settled. In that view of the matter, take the prayer clause and all proceedings pursuant that are hereby quashed.
All right. My lord, another 3 cases, connected matters. May I give the numbers? 3415, I will
So taken on board, same order. But what is the corresponding quashing?
question 406, 420.
No, the GR case numbers are the same or different?
Different complaint cases, but the occurrence one.
Then we list it tomorrow, sir. We list it tomorrow.
All these three cases.
Three cases we list it tomorrow.
Obligement.
All right.